I guess there are no apologies. So today we have only one item. Honorable Nivotrohan.
Thank you very much, Chair. Just stating that Honorable Ngola and Honorable Janki are in another committee meeting this morning.
Or the Section 194 committee.
Yes, Chair.
That will be noted. Thank you very much, Honorable Nivotrohan. That will be noted as such. Today we're dealing with only one item, hate crime, hate speech bill. Members would be aware that we've gone through the bill last year, and we have identified in all the clauses various options that members had prepared or were advocating for. So in some instances, we've got option 1 and option 2. In fewer instances, we also have option 1, option 2, and option 3. Mr. Dupree is going to take us through those options so that we can see that all our options are captured. After that, we would, once we have gone through the options, then we would start going through the prepared options so that we can move towards finalizing this bill and deal with other bills that are urgent before us. Honorable Swart, you would know that one of the issues we discussed last week in your absence was the prioritization of the judicial matters, because it has in fact a section that we really wanted, and we have pronounced on it, the issue of people who had pleaded guilty during COVID times, and as a result have got criminal records. The expungement of those criminal records, it's one of the bills that this committee would want to finalize as soon as possible. So we are hard pressed for time, so we'll try and ensure that each bill we do it. In fact, we applied ourselves diligently, and we want to produce proper bills, apply our mind properly, but at the same time, we must ensure that we finish those bills as quickly as and expeditiously as we can, so that we can be able to cover as many bills as possible. Can I now hand over to Mr. Dupree?
Good morning, Mr. Chair. Thank you very much. And good morning to the members of the committee and my Deputy Minister. I don't know whether my Deputy Minister would like to say something at this stage, but in the meantime, I will share my screen.
Deputy Minister.
Thanks, Chair. Yeah, I know you've given over to Mr. Dupree, and I think we want to get through things. So let's. I don't really have anything to say. Maybe just to say that since we met last, there have been a number of incidents of crimes. Mazelsport, for example, which, if this bill were passed, would be a hate crime. There are issues, probably this issue, this case of this man beating up a black teenager for a assault cellar may also have been a hate crime if this legislation had been in effect. So I think that there's a lot happening out there, and this legislation is urgently needed, and it does need, and I hope it will be given priority. Thanks, Chair.
Thank you very much, Deputy Minister. Mr. Dupree.
Thank you, Mr. Chair. So the working document is now on the screen. Once again, the short title can be reviewed at the last minute of deliberations on the bill. No substantive amendments to the preamble. The definition of communication, the proposal was that oral statement be replaced with utterance. I don't think there's going to be much controversy around that. Then we've got the definition of harm, Mr. Chair, and we've got options there for the definition of harm. For example, option 1 refers to substantial emotional and cultural detriment. And then a decision must be made if that option is chosen to either replace substantially with severely. And mainly option 2, the same there, except for the proposed deletion of social or economic harm. Option 3 then is also an option that the committee wanted. There's also decisions that must be made if that option is chosen with regard to replacing objectively with substantially or severely, those words. Then the department was requested at the previous meeting of the committee to propose definitions of culture and social. Now, the committee hasn't had a look at this yet formally during its deliberations, because it was included in the current version of the working document. So the department proposes that if the definition of culture is accepted, then it would mean that culture is the sum total of the behavior, beliefs, values, and symbols of an identifiable group of persons that are unique to that group and that are transmitted from one generation of that identifiable group to the next. And cultural will then bear the same meaning as culture. With regard to social, the proposal there is that it would mean persons who associate with each other as a result of their common heritage or common understanding of their personal characteristics, attributes, or preferences. I don't know whether you would like me to pause here, Mr. Chair, because this is now something new in the working document. Or should I proceed, Mr. Chair?
Well, I would be guided firstly by hands. Alternatively, what we can do is let's say we go through each clause to check if, let's say with option 1, option 2, option 3, whether the options that are there covers what covers the options that members had been advocating for, before we come to the merits and the demerits of each options. Will that be in order, members?
That's fine, Chair.
Yes,
Thank
Chair.
I think it's also fine, Chair.
Thank you very much. So let's go to option 1, harm. There are 3 options. Do those 3 options cover what was discussed? Honorable Horn.
Thank you, Chair, and good morning to all colleagues. I think by and large, the options covers what has been discussed, Chair. In looking at the document, the one thing that I don't want to say bothered me, but which I remember is that my recollection is that the strong and substantial was basically the product of some input from Honorable Swart around the use of the term deep by the Constitutional Court in Kwalani. And in that sense, what I think we need to consider as well is whether specifically substantial necessarily means the same as deep. So one words ultimately, and the meaning of words are important. And I would just want some opinion from both the department and ask colleagues to consider whether substantial goes as far as deep, strong might go as far as deep, but the difficulty with substantial might be that something is either, let's say, insubstantial or immaterial or substantial, and that would mean that something could be substantial in nature without necessarily going to the same impact as the word deep, specifically if one then links it to harm or detriment. So I don't know whether the department has looked at the, let's say, the meaning of all of these options. And I know, as I said, it was ultimately the product of some input by Honorable Swart. So I'm not chairing, but maybe he would also want to give some input on this. Thank you, Chair.
Thank you. If I understand you well, is that maybe before the department explains themselves, that instead of the word substantial, we substituted deep, emotional, and psychological.
Yes, Chair, specifically given that that was the term used by the Constitutional Court in Kwalani. Thank you.
Thank you very much. Honorable Maseko Jele.
Good morning, Chair, and good morning, colleagues, and the team with Deputy Minister. Chair, it's just a question of clarity. I want to find out, are we already maybe discussing and choosing option, or is Mr. Dupree going to go through all this and then we discuss and come back and choose? I just wanted to, I'm a little bit maybe confused a bit so that we don't, one does not leave the opportunity of choosing the option maybe when time comes. I wanted to get clarity, Chair.
Yes, no, we are correct, Honorable Jele. What we will do for now is to say, have all the options been captured and in the manner that we want them to be captured. That is the first point. Then once we are satisfied that the options have been captured in the manner in which we wanted them to be captured, then we will come to say, which options are we preferring? We are going to debate as to which options are we preferring. Then if, let's say, majority prefers option 3 instead of option 1 and 2, that will be the debate. Then we move and then we'll go to the next options. Once we are done with the debate and choosing the preferred options, then we put the whole bill before the committee for a final debate and adoption. So for now is to say whatever we discussed is reflected here in the manner in which we wanted it to be reflected. Then thereafter we are going to go to the debate on the options themselves. So now it's more of an arrangement, kind of more administrative, to say we said to the department they must go and work out the options. Have they done that to our satisfaction? Then once we are satisfied that they've captured everything, then we go to the, we choose the options. People can express themselves in the options that they would want. And then we move towards finalizing the bill. I hope that is answered you, Honorable Jele.
Yes, Chair. Thank you. Thank you very much.
Thank you very much, Honorable Swart.
Chair, morning again to colleagues. I think the question now is whether this correctly captures what we asked, and I think it does to a large degree. The second question then is, Mr. Horn is correct. When we discussed this, I raised the issue of deep, and substantial was put in as a synonym of the word deep, and I'm not sure exactly if it is. So it could be when we come back, we might want to just look at whether the word substantial goes far enough or whether strong. And then in that context, I don't want to reopen the debate. We've come a long way, but I think it's necessary for us to understand, because I was under the impression that substantial means the same as deep, but maybe it doesn't. I hear what Mr. Horn says. So maybe for now, we can just record that it does capture what we asked. I think strong is a good word as well as an option there. And then maybe we might spend, because again, as I've said before, and we all agree, this definition is at the heart of the bill. And it's so important for us to understand, yes, the Deputy Minister raises certain issues that can be totally justifiable and would probably qualify when you look at the Kwelani judgment of hate speech going beyond mere offensive expression. Bearing in mind that mere hurtful language in everyday parlance does not constitute hate speech. Even offensive speech is protected by freedom of expression, but I think the examples he gave would qualify. Thank you, Chair.
Thank you very much. Before I go to the Deputy Minister, Honorable Horn, is that an old hand or a new hand?
My apologies, Chair. It's the beginning of the year. I'll take it down immediately.
No, thank you very much. Honorable Deputy Minister.
Thanks, Chair. No, just to say, and I don't know if the officials would want to respond. I mean, there wasn't a reading in of deep or any other adjective in the Kwelani judgment. As you know, they did a reading in, and they didn't deem it necessary to put that in. What has been added here in the options is an adjective describing the detriment or the harm, which is now detriment, that it must be substantial or it must be strong. And then in addition to that, it must objectively and substantially or severely, that seems to be right the way through in all three options, undermine the human dignity. So there's two new conditions that have been put in. I'm trying to find the references to deep in Kwelani. I don't know if the officials are more familiar with that section, but just to note that it was not deemed important enough to put into the reading in of the section that the court did. Thanks, Chair.
Thank you very much, Deputy Minister. Mr. Dupree and Ms. Botha.
Thank you, Mr. Chair. I think the important thing of the proposed amendment to the definition of harm is that it is much more stricter than it was compared to the definition as it was in the introduced version of the bill. And the very important aspect, if I may say, for me personally, is to bring out clearly that it must be objective and not subjective. Personally, I would prefer the word substantial instead of strong. As the Deputy Minister correctly indicated, is that the Constitutional Court didn't do a read-in with regard to or reference to the word strong. So it was a part of the argument or the judgment of the court. It's not a familiar word in legislative drafting. So I'll leave it at that, Mr. Chair. I don't know whether Ms. Botha would like to add anything.
Ms. Botha.
Thank you, Chair, and thank you to the DM and Mr. Dupree. I think that I am mainly covered. Save to add that I have just looked up the legal definition of the word substantial, and I just want to read for you, belonging to substance, actually existing, real. So something which exists and is real. And like Mr. Dupree said, substantial is more often used in legislation than deep. And just to go to the DM's point, The reference to deep in Kwelane, the Concord judgment, is at para 106. It was not read into the order, and the excerpt from para 106 of Kwelane says that the concept harmful connotes deep psychological and emotional effects. That is all I have to add. Thank you, Chair.
No, thank you very much, Honorable Swart.
No, Chair, I'm basically covered by that. Yes, I was just going to give the reference in Kwelane, which does cover that. But I do think that there is scope for a chat, for a discussion around, because just to mean real, I don't think it necessarily gives the same connotation as deep emotional. So, but we can come back to that. Again, bearing in mind, maybe we can spend a bit of time on this issue because this is at the heart of the bill. I agree, there is no reading provision, but it does give us guidance. I think elsewhere, the judgment also says harmful can be understood as deep emotional, psychological harm. And then the second element of severely undermines. So thank you, Chair, for that.
Thank you very much. Deputy Minister, is your hand up? Or is it
it is up. Chair, I mean, the judgment was not saying that the word deep must be there for harmful. In 106, now that Ms. Boert has referred me to the section, the court was summarizing the South African Human Rights Commission's position. So I would appeal that when we refer to judgments, that we do actually refer to it accurately. The court was not saying that it must be deep, and in fact, it said simply deep psychological and emotional. So I just feel that it was a bit of a misrepresentation as to the Kwelane judgment. The 106 is the Commission contends the distinction between hurtful and harmful, so they're summarizing what the Commission says. And again, on the one hand, hurtful refers to expression and causes emotional pain, but the concept harmful connotates deep psychological and emotional effects. It's the Human Rights Commission's argument. It's not what the court said. So, look, I don't want to get into nitpicking over one word, but I think that the issue is that we accept that there should be some qualification of the detriment. It's a question then of substantial or strong. Those are in the two options that you put. The word deep wasn't put in because it doesn't have so much of a legal sense. And I think we should leave out the word deep. Because it's not what the court actually said. It's something that they raised, or that the Human Rights Commission raised. Thanks, Chair.
Thank you very much, Honorable Masakwa.
Thank you very much, Chair. I just want to go back to what Ms. Boert said when she was explaining. There's something that she said about the weight is not familiar. It's not familiar in legislation crafting. I just want to understand that. Does it mean that if it's not familiar, the word is not familiar, but the committee feels that it's relevant, it cannot be used? It's that the question. We can't use that word because it's not familiar to the courts, even if we feel that it is relevant. That is the question number one, Chair. Question number two would be, the last time when we were discussing this issue, was the argument not that that weight substantial is the legal weight that is normally used, and if maybe we use another weight, it's my understanding, my interpretation of what we said last time, Chair. If we don't use that weight, we might be found maybe on the for lack of better words, on the wrong side of words that are used in court. Was it not the understanding of what came out from the discussions of the last time we were dealing with this issue of this definition? Thank you, Chair.
Thank you, Honorable Jelle. Honorable Breitenbach.
Thanks, Chair, and good morning to everybody. Chair, there's a different reference to harmful, the term harmful or harm in the Kulani judgment in paragraph 154, which explains, in my view, why it was not read in. And if you read in the judgment, it's clear on a plain reading, harmful can be understood as deep emotional and psychological harm that severely undermines the dignity of the targeted group. So it may not have been read in simply because the court has expressed a view that the plain reading thereof is very clear. So I think that a discussion on this issue will be necessary. Thank you.
No, I just want to.
Honorable Swartz, is that a new hand?
No, Chair, I just wanted to state that, and maybe we should start off on a good note for the new year. That was my reference, was from paragraph 154. So there's no, I think the DM is on, he should also read the judgment correctly, because it wasn't a mere comment by the SA Law Human Rights Commission. It was what the Constitutional Court said. Thank you, Chair.
Thank you very much. Can I suggest the following? Can we move to the other clauses? One, can we agree that the three clauses do capture what we discussed last year? Maybe Mr. Dupree, you can work out on the fourth option, which will cover the word deep, as articulated by Honorable Horn and Honorable Breitenbach. And so then we'll have option 1, option 2, and then option 3 will be strong, and then option 4 would be deep. Then we'll come back once we are done with other clauses to have that particular discussion, so that we are able to move to other clauses to check whether they have really been captured in the way we have. So my understanding of the discussion so far is that there is a space to include option 3, option 4 with this word. Then we will come back to argue the merits and the demerits of which word eventually we are going to be taking to be part of the bill. Will that be in order? Silence means consent. Can we move to the next item, to the next clause?
We've got the option for the definitions of.
Sorry, members, can we just have, I must change gadgets.
Yes.
There's load shedding. Can we just have 5 minutes to change gadgets?
Yes, Chair.
Thank you very much. Thank you. had decided to imprison me. I think he was trying to stage a coup. I was trying to log in, but he was not allowing me in. I think he was assisted by Honorable Breitenbach. Thank you very much. Can we
When if I wanted to do a coup, I would succeed, not attempt.
No, let's go to the next clause.
Can you just give me a moment?
Yes, Honorable Deputy
Yeah.
Minister. Sorry.
No,
Sorry.
just with regards to the earlier issue on deep and particularly Mr. Swart's comments. If you remember when I spoke, I had said I couldn't find the reference in Kwelane. And then I was referred to 106, I think it was, as where it is just a reference to what the Human Rights Commission says. However, having looked further after Ms. Breitenbach's input, it is in 152 or 154. So I apologize and withdraw for any aspersions I may have cast. I wasn't aware of it. I'd asked where it was told 106 or heard 106 and wasn't aware of 102 and 154. Sorry, 152 and 154. Thanks, Chair.
No, thank you very much. I think apology is accepted, Honorable Deputy Minister. I think let's proceed, members. Then we agree that now, as things stand, I think all our options have been covered. Then we will be able to have a discussion, in fact, a robust discussions on the options, because everything that we wanted to be covered is already covered. Now, let's go to the next option.
Thank you, Mr. Chair. Now, that was a request that was made at the previous meeting of the committee, that definitions of culture and social should be included in the bill. If the committee decides to retain those terms in order to assist the courts in interpreting what culture and social refers to within the ambit or the reference of the definition of harm. So the department has now proposed a definition of harm to the committee and also social. I've earlier this morning went through the definitions with the committee. I don't know whether you would like to hand over to the members of the committee, possibly for a discussion. I might just, let me leave it at that then. Thank you, Chair.
Thank you very much. Members, any takers on the definition of culture and social? Honorable Horn.
Thank you, Chair. And firstly, thank you to Mr. de Pre and the department for assisting in this regard. The one thing that, and one doesn't want to move the goalposts every time. The one thing, looking at the definitions, I think from just a first reading, culture seems to be the way I at least understand culture, and social has that freedom of association element. So in that sense, even though it is fairly broad in nature, I understand where the department is coming from. The difficulty, however, is that these are now new concepts, and what I'm just wondering is, how would harm then be linked to cultural or social detriment ultimately? So we have this definition of culture and social now, and from previous discussions, I recall that we've said, yes, of course, sometimes exclusion from the group can in itself be harmful and have a detrimental impact. And as I say, I don't want to want to create the impression that one is just not, one wants to move the goalpost. The difficulty, however, to be blunt, is that I don't think the definitions brings us closest to understanding what is to be meant with social harm or cultural harm in the context of the bill necessarily. I don't know whether the department can assist. Thanks.
Thank you very much, Honorable Maseko Jele.
Thank you very much, Chair. Let me just say, Chair, thank you very much to Mr. Dupree and the department for coming up with the meanings of those two names, because I think for me it was important that we should have them, because we did include the issue of culture and social in our grounds and characteristics. So I thought that this is important, even though we have to go into details as to the relevancy to what we are talking about now. I think the only one that maybe I was also going to comment about is this one of social. Yes, social means a persons who associate with each other as a result of their common heritage or common understanding of their personal characteristics. I think that one of common heritage, I think the word origin also may be relevant if we are saying they associate in terms of their origin also, because remember here we are addressing also the culture of the history where we are coming from, Che, where we were, there's the group of segregation, you know, that separation of this group will be this side and this one will be, it was not only done by the issue of preference, it was done also according to the races. This race will be grouped this way, this one will be grouped this way. So I think we were grouped according to our origins, culturally and racially so. I think that word must also find expression there, because if we're going to put it like this, it will be like the issue of friends like this, you know, and also the issue of because I want to associate with that group, so we must be catered for. Here we are talking about the race, the races, the issue of races, segregation in terms of race, in terms of culture. So I think that to me, it has to find expression for this, for these definitions to be relevant to what we are talking about. Thank you, Chair.
Thank you, Honorable Jele. Honorable Swart.
No, thank you, Chair, and thank you to the department for the definitions. They probably do capture what is meant by culture and social, and then obviously one needs to have a discussion as to the broadening then as a result of the definition, and whether the context of including the words culture and social, and whether it does then satisfy what is understood by hate speech in the context of which those words are used. I don't have a problem with the definitions, but I just want to make the point that it does result in very broad concepts, such as a symbol that might be offensive to certain people, or a belief that might be offensive to certain people, but the mere fact that it might be offensive does not necessarily, and you express offensive language about, you express something in objection to that, even if it is offensive to the person that holds to that belief or to value or symbol, that does not necessarily mean it is hate speech. So I think we need to grapple a little bit with this and the implications. Maybe we don't have to spend maybe at a certain stage without delaying it all, but just to understand to what degree is there an overlap between culture and social, to what degree is the issues of race, as referred to by the Honorable Maseka Jeli. Race is already defined elsewhere, if I understand correctly, or referred to elsewhere. We understand that issue. So there is a lot of overlapping as well, but I appreciate the department's definition. That was in accordance with what we asked them to do. Thank you, Chair.
Thank you very much, Honorable Jacob Mulder.
Thank you for recognizing me, Honorable Chair. I will be short. I just wanted to add to what Honorable Swart said, that our race is already defined elsewhere, as I understand it, but we should ask ourselves the question whether race should be included here. I think the whole idea of this piece of legislation is not to divide people. If you're going to be defining race explicitly, then some other paragraphs need to be changed as well. So I still wonder if option 2 wouldn't be better, and if the whole idea of cultural and social should be included as well. If we're going to define it broader, we're going to find ourselves legislating ourselves into a corner. Thank you, Honorable Chair.
Thank you very much, Honorable Horn, then followed by Honorable John Jeffrey.
Yes, thank you, Chair. And thank you for allowing me a second opportunity. I want to say that I think my first question and the relevance thereof is somehow underscored by the input from Honorable Swart, in that my understanding was that what is to be protected is the causing of harm or detriment to somebody based on the exercise of their cultural rights or social activities. Whilst quite clearly the Honorable Swart, and I'm not saying I'm right and he is wrong, understands it that you can, through the exercise of culture or social activities, cause the harm. And I think there's a big difference in there, in that I think we must think very carefully whether we ultimately want to criminalize cultural or social practices, or whether we want to protect cultural and social practices, of course, for as long as they are not unconstitutional in nature. That's always the first principle. But in that sense, I do just want to stress that I think we must think careful about what exactly would then constitute social and cultural harm. If we are to maintain those two terms within the definition, we have at the options a option without them, which is of course the product of some of us questioning whether those should be included. Thank you.
Thank you very much, Honorable John, Honorable Deputy Minister.
Thanks, Chair. No, I'm just, I thought what we were meant to be doing was to be going through the options and seeing if they capture the different positions before, and then we'll be coming back to debate which option should be selected or not. So obviously those people who are not in favor of social or cultural harm would, or economic harm as well, would be going for option 2. And then this option for the definitions of cultural and culture and social would fall away. So are we not starting to debate what we've got to do later? It seems to be accepted that the definitions of culture and social do generally express what people wanted, although the department would need to look at the inputs from Honorable Maseko Jele. Just also then to seeing there has been some discussion to highlight that the judgment, Majid's judgment, did quote from the Concourt in State Human Rights Commission versus Kumalo, which identified 3 kinds of harm, and the third was harm to social cohesion. So already the Concourt has made reference to harm to social cohesion, which could be defined as social harm. The question is whether we need harm and culture, which was a later input into from the public submissions. But Chair, I would suggest those are issues we look at when we come back. It's a question of, does this capture what the different views that people have, not actually coming to a position. Thanks, Chair.
Thank you very much. Honorable Jele, having heard what the Deputy Minister is saying, are you still of the view that we would need to expand the definition of social in the manner in which you were articulating?
No, Chair, I think it will depend with, like he was explaining, Chair. I think let's go through what we wanted to do and then we will go back as long as we are covered. Thank you, Chair.
Thank you. Can I suggest members that option 1 is what we have now, which is the 2 definitions as they are, and then option 2, I think is what I think is Honorable Mulder. It's an option without these 2 definitions, which means when we say they are not necessary, so we'll come back to debate those. Will that be fine?
Yes, Chair.
That's fine.
If there's still a need for by debating after we have made our choice. Thank you, Chair.
We're still going to come to debate, but for now, it's more of saying what the document does it capture, what we instructed them to do last year. That is basically what we are doing. Then once we are done with that, then we come to the substantive debates.
Okay, Chair.
Thank you very much. Can we proceed, Honorable Dupree and Honorable?
Sorry, Chair. Swatcha, I just wanted to clarify, I'm not disagreeing, but I think at the beginning you did indicate that these 2 terms, culture and social, had been added. So they were new. And that's why maybe we had a brief discussion on those 2 items, because they were added in. They weren't suggested by any of us. But I do appreciate the short discussion that we had on those 2, with the understanding that as we're going forward now, it's to discuss whether they've been captured correctly, the insertions. Thank you, Chair.
Thank you very much. Mr. Dupree, Ms. Botha, can we proceed?
Thank you, Mr. Chair. The definition of hate crime, hate speech, then with regard to with reference to the definition of characteristics, the department was also requested to provide options there. Under characteristics, then the option with reference to age is then to exclude reference to age, as well as then in paragraph F, the option is to include race or skin color. Paragraph I, the option there is to exclude reference to language. Subparagraph K, option there is to exclude reference to occupational trade. And then with regard to subparagraph L, the option is to exclude political affiliation or conviction. Now this, just be mindful, Mr. Chair, if I may, characteristics refer to clause 3, which is the the hate crimes provision. And then the remainder of the amendments in that definition are consequential in nature. Then when the first working document was prepared for the committee, a separate definition of grounds, insofar as it applies to clause 4, the hate speech provision, the original proposal was to define grounds as bearing the same meaning as characteristics, excluding then, of course, occupational trade and political affiliation. And now there are 2 additional options which the committee has had a look at the previous meeting of the committee. The first option is to include paragraphs A to J, and then the second option is a bit more restrictive.
Yeah.
Who is that now?
Sorry, Chair, I think it's one of the sign language interpreters. And then option 3 is then also a bit more restrictive than the previous 2 options. Then with regard to clause, that brings us at the end of clause 1 then. Clause 2 was one of the few clauses in the bill that remained unscathed by the deliberations of the committee members. So that is still the provision as it looks like in the introduced version of the bill. Then when we get to the offence of hate crime, we could just maybe just highlight to the committee then, nothing changed here except for, you will recall in a previous working document version, the definition of hate speech or the reference to the offence of hate speech was excluded or was proposed to be excluded from clause 3. And now the addition is to also exclude that first part, the common law offence of criminal injuria. So sub 1 is then the version of the provision as it was introduced. The proposal is that a mere redraft of the existing provisions to maybe make it a bit more user-friendly. And then also the addition there is the reference to the common law offence of criminal injuria. Then with regard to subclause 2, nothing new there, Mr. Chair, and nothing new with regard to subclause 3. When it comes to the offence of hate speech, the department was also requested to provide options there. I think it is quite straightforward. If I remember correctly, the second option is the option sorry, Chair, I see there's a hand.
I can't see Honorable Swart.
No, Chair, on the option 2, I didn't want to interrupt Mr. Dupree. Option 2, I'm not sure if that correctly captures. We did a lot in a very short time, but just I'm not sure if the insertion of the word cause. As we are just dealing with capturing now, I can only suggest maybe we just put another option in to delete the word cause, because I don't remember whether that was the suggestion. I definitely suggested remove the words be harmful, but I stand under correction whether then to replace it with the word cause. I'm not sure about that. So it could be that may I just suggest so we don't have a huge debate on whether it captures the word correctly, just have another option where we don't have the word cause in. Thank you, Chair.
Thank you. Which will be option 3. Honorable Horn.
Yeah, thank you. No, I agree with the Honorable Swart, Chair. My recollection is also that one of the arguments raised was that if we go closer to the wording used in the Constitution, it is ultimately about inciting harm. But yeah, I don't want to belabor the point. I think his suggestion to add a option 3 there is a good suggestion. Thank you.
Thank you very much. Let's proceed.
Thank you, Mr. Chair.
Sorry, Chair. I put my hand. Can I speak?
Yes, Deputy Minister.
Yeah. So I was just going to ask in terms of for simplifying, if option 2, and here I would want to check with the drafters, if option 2 was seen to be Mr. Swart's option, instead of an option 3, and unless anybody actually wants cause that's here in the meeting, the virtual meeting, shouldn't it just be option 2 be amended to what Mr. Swart wants? In other words, keeping it as 2 options, not 3. Is there anyone who likes option 2 or who it belongs to? If not, then can we just make option 2 as amended, Mr. Swart's and Mr. Horn's option?
I think, DM, we might, I think that would be a substantive discussion. I think just for the sake of keeping things as we agreed, I think let's have this option 3, and then when we debate, then we can come back to the options, because I think now, I think going forward, people would start wanting to eliminate options that are already here, which will be part of the substantive discussion. I'm not sure whether you understand me. I think it's much easier when we add another option, keeping those that are already here. So that, but when we come back, then we can eliminate the other options.
I think, sorry, Chair.
Honorable Swart.
No, I think what the DM is suggesting, that nobody actually suggested the insertion of the word cause. So it's not correctly reflected here. That's why he's suggesting there isn't a need for option 3. But we would then just amend option 2 by deleting the word cause.
Okay.
I'll leave it in, yeah,
okay.
Is that correct? Yeah.
Yes, thanks, Mr. Swart. That is correct. It wasn't deleting any option that anyone wants. It was checking whether anybody did want cause. And if not, then we don't need to keep it, because my understanding recollection was that option 2 was Mr. Swart's option. And if he wasn't happy with the wording that's here under option 2, let's put in the wording that he wants, because it's his option, unless, of course, there's anyone who does want cause to be there, but I understood it had come from him.
Okay, no, I understand. My apologies, Honorable Deputy Minister. Can we do that?
Thank you, Mr. Chair, and I apologize for misunderstanding the committee at the previous meeting, but I distinctly remember that I inserted those words, deleted those words, and inserted those words, but let's leave it at that. Chair, we can proceed with your permission. There's not much more that we need to indicate to you in clause 4, the proposal and the options, if I remember correctly, have been discussed in the previous committee meeting. With regard to clause 5, there's also not anything else or new that we need to bring to the attention to the chair of the chairperson. Penalties or orders, those remain the same, except to indicate to the committee then that with regard to penalties, there's two options. The one, or option one, is the provision as it was introduced in Parliament, and then option two is to combine paragraphs A and B, and instead of distinguishing between first and second offenders, just to place a maximum period of imprisonment to the discretion of the courts, and that maximum period will not exceed 8 years. National instructions and directives, clause 7. There's nothing new that we need to point out to the committee. As well as clause 8. Clause 9 has also been discussed in the committee. With regard to the regulations provision, the department was requested to prepare an additional, not an additional option. The first option is the version of the provision as it was introduced into Parliament. And then the second option is, which is more of the regular provisions that we have with regard to regulations, by not requiring that Parliament should approve the draft regulations before they are published in the Gazette. Laws amended, straightforward. Short title and commencement, straightforward. Mr. Chair, I hate breaking our momentum at the moment, but if I may kindly request you to allow us just a 2-minute body break, please.
That is fine. What is the time now? It's 11:45. Can we come back at 10:02?
Yeah, I also think so.
Okay, 5:02. 5:02. Can I now suggest that we go to the first clause? I think it's the definition of harm.
Honorable Chair, Honorable Nieuwenhuizen's hand is up.
Honorable Nieuwenhuizen. Honorable Nieuwenhuizen.
Chair, my apologies for interrupting. I would like to ask a question for clarity. I hope you'll bear with me. On page 13, 7.1, A.2, Roman letter 2. It says, I'm just looking for the clause, the circumstances in which an investigation in respect of the hate crime or hate speech may be discontinued. That's the one. And then in the second point after that, I think it's just before the, excuse me, the end of page 13, because it says AA. So just before the end of page 12. Sorry, that was the mistake. Because it says an offense made by withdrawal or persecution will be stopped. So with these two phrases, if the team or the deputy minister could clarify, particularly in terms of withdrawal of prosecution. So I'd like to understand what the implications of these clauses are. Thank you, and please could you unpin?
Honorable Deputy Minister.
Chair, maybe the officials, I unfortunately missed some of Ms. Nieuwenhuizen's input, but basically the purpose of 7.1, which is a new clause which was added as a result of the public submissions, is for the National Commission of Police to set out, as was done, what was in the bill was under 2, what's now 2A, the processes for the manner in which cases are to be dealt with, including the circumstances in which they may be withdrawn or the prosecution stopped. So 7.1 is a similar clause for the police, the manner in which an investigation may be discontinued, the conditions. So it's basically saying that the National Commissioner must set out instructions in this regard, so people know when a hate crimes or hate speech matter, when the investigation can be withdrawn. But maybe if I can hand over to Mr. Duprier or Ms. Buerta, if I've misunderstood Ms. Nieuwenhuizen, Honourable Nieuwenhuizen.
Thank you, Mr. Chair. Mr. Chair, we've had we've got similar provisions in the Sexual Offences Act, and these provisions are to ensure consistency throughout the country with regard to the investigation and the prosecution of these offences. So it is a provision which is mainly aimed at providing consistent application of the provisions of the bill countrywide. It's sort of, I wouldn't want to call it a precautionary provision, but it's aimed at ensuring consistency. Thank you, Chair.
Thank you very much. Honorable Nieuwenhuizen, are you covered?
I have my hand up, Chair. So no, I haven't yet been covered.
I have a difficulty, Honorable Nieuwenhuizen, because we are still going to come to these clauses. I think what you are raising might result in a substantive debate. So what I would suggest we do is that we start from the beginning, because as we are going to come to this to this clause, and maybe you can have your issues as substantive debates that we can deal with.
That's fine, Chair. Thank you.
Thank you very much. Members, can I also suggest that we agree on time? I would suggest that for today, maybe we can end at 1 or 1:30. But I think let's agree on time. At what point are we going to end for today? Can we agree on 1:30?
I'm okay with that, Chair.
Thank you very much. Any counter? No counter?
1:30, Chair, 1:30.
Thank you very much. Let's proceed.
Chair,
Honorable Horn.
yeah, my apologies, but my hand's been up for a while. I wanted to.
Sorry, I just it's a new gadget. I did not see your hand.
Know that it's fine, Chair. I know you won't do it on purpose. Chair, I just, before we went back to the beginning, wanted to say that in terms of options, I believe there's one part of our previous discussions which is not properly encapsulated through options, and that's around the exemptions. So my recollection is that when we discussed the so-called exemptions, and my apologies, the working document, it's subclause 2 of, yes, I think Mr. De Prio or whoever scrolling down is nearly getting there. My recollection of our discussion of the exemptions was that there was a bit of an unease linked to an extent to the 2 options around the penalty. And some of us felt that if direct imprisonment is going to be the applicable penalty, I know there's options at this stage around that one has to look at a further tightening of the exemptions. So I don't necessarily want, for the sake of progress, for us to now settle on inserting options. I just want to, for the record, given the fact that your guidance at the beginning was we must just firstly state whether all of our previous discussions is properly encapsulated in this working document. I think there was a view amongst some of us previously that if we go for the option around direct imprisonment, that in terms of the exemptions, we would have a difficulty with anything, I want to say, broader than, for example, physical harm. So there is still included there at the exemption clauses. That's the one about the artistic and religious freedoms, if I'm not clear. At this stage, there's still also social and emotional harm included in there. And I think the argument remains that, yes, whilst we know that there is a criteria here that this must be objectively determined, the reality is that through artistic expression or even a religious activity, some with a bit of a more of a fragile disposition and composition could objectively experience emotional distress and harm. And I don't think it would be fair then that results necessarily in direct imprisonment. So without belaboring the point, I just want to place it on the record that depending on where we go regarding that, we are still of the view that that might need to be tightened up. Thank you.
Thank you. So you don't have a formulation to suggest as an option that can be looked at?
Well, Chair, firstly, in an ideal world, but I obviously want to don't want to force the hand of the committee. I would think that in terms of those exemptions, the best would be for us to only include physical harm at this stage. But as I say, from my side, I think it's closely linked as to what is the type of penalty that could be imposed. I would just principally have a big problem of imprisoning somebody who practices either artistic expression or religion, and who might cause, objectively speaking, some emotional harm to somebody, not necessarily because of the expression, but because of the fragility of whoever is then whoever is then harmed. I would have a principal objection in respect of direct imprisonment in those cases. But maybe if the committee would be agreeable, one could look at an option of at the exemptions. Firstly, determining that those I want to say the cancellation of the exemption, or because it is phrased in a way where there is an exemption, but then the exemption is also cancelled in certain instances, that only be cancelled, so to speak, given that we're living in an era of cancel culture, in the event of physical harm and no other forms of harm. Thanks.
Thank you. Before I go to Honorable Masego Jale, dear Mr. Dupree, Ms. Botha, were you able to understand that, and is there any formulation that you can think of to capture that? Because we don't want to leave anyone behind, especially in the capturing of various positions, so that when we debate on the basis that everybody's input is in, and then we have a discussion as to which one do we prefer, without having first excluded anybody's inputs as a base point from which we are going to be moving from. Maybe I must take Honorable Jale and then Honorable Deputy Minister.
Thank you, Chair. I think you have covered me, Chair, in terms of the department having to look into another option, because to me, Chair, the first one was just fine, because I just felt like, we don't want, people have to learn to respect people, whether you are an artist or you are a preacher. You must be careful of what you are saying or what you are doing, because nowadays, Chair, we have experienced a lot of things that are happening within those institutions like churches, where we never thought that we would experience that. So the law should cover everybody, whether you are a preacher or you are not a preacher, because of the experience that we have. So people should learn to live and behave in a manner that is not harmful to other people, whether you are in church or outside church. Thank you, Chair. Or you are an artist or not an artist.
Thank you, Honorable Jale. Honorable Deputy Minister.
Thanks, Chair. Look, as I understand it, Mr. Horn is objecting to the provision that allows the court to give a sentence of imprisonment in hate speech. Obviously, it's the court, it's not a minimum sentence. It's not saying that there must be sentences of imprisonment. It's allowing the court to do that. Remember that in the Momberg case, the court did that. It found that she was, it went into the question with sentence and found that actually a sentence of imprisonment without the option of a fine was applicable. I know she wanted to appeal. I'm not sure what happened with that. So it's a question I think of, is Mr. Horn disagreeing with that judgment in Momberg? Because it's the court that is going to impose the sentence. It's not a minimum sentence. My understanding then is what Mr. Horn is saying is if the court is able to impose a sentence of imprisonment, then he feels that harm should be limited to physical harm, which then would be a different option under the definition of harm, a fourth option. So that's my understanding. But let me just point out that, I mean, this legislation is trying to address racism, which is usually, well, sometimes it can be physical, but it is usually emotional, psychological, social harm, which can, and that harm can be quite severe and can upset the social cohesion of the country quite a bit. But my understanding is that, as I said, it's a fourth option that he wants for harm, if I'm correct, if the imprisonment is continued. Just with the partial exemptions to point out, and their partial exemptions is that for everybody else, there's a higher bar in terms of the definition of harm and the requirements for hate speech. In the case of the categories that we've listed there, there's a lower bar which follows what's in the Constitution, that what they do, what they express, what they say must not constitute incitement to cause harm, which is what the Constitution doesn't allow anyway. Thanks, Chair.
Thank you very much. Members, can I still suggest that the department works out an option that would take into consideration what they have raised? Of course, we will come back and argue the merits of it and the demerits of it, like all other options that are here, where we are going to take each one one by one and argue the merits and the demerits before we finally agree on the way forward. The way forward might well say that no, we don't need this, or we need this. But I think for now is generally to have a base document that takes everybody's views, no matter how different from each other they are, and then we are still going to have a sifting mechanism now through the debates as to look at the desirability of each.
Chair?
DM?
No, just to get clarity from Mr. Horn, am I correct? I mean, and this would help the department, maybe they are clear, that he wants an option under the sentencing relating to hate speech to remove the provisions to allow the court to sentence people to direct imprisonment. And if that option is not accepted, he wants an option under the definition of harm to limit harm to physical harm. I just want to check if I'm correct. Maybe I've misunderstood wrong, and also if the drafters understand it the way I understand it.
I think that's a fair one. Honorable Horn?
Yes, yeah, thank you, Chair. That's not exactly what I meant. What I meant is that not necessarily to say I want a fourth option around harm, but to say in respect of the partial exemptions, I would advocate for that to be more narrowly defined, or no, that's not the correct term, but that for only physical harm to apply there. And let me make an example and also point out that with respect, I don't think the Momberg case can be instructed via. I don't think Ms. Momberg either was an artist who was busy with artistic expression, or was busy with religious activity, or a journalist for that matter. So in respect of the partial exemptions, and I'm not, once again, also not talking about race. I think we've traversed well enough in this committee that racist speech is unprotected in terms of our constitution. But if I may use another example around, for example, religious expression and religious activity, wherein at least some versions of the Christian religion, to be gay is seen as a sin. And if one does not include the incitement to harm, to include physical harm only in those instances, that would mean that a pastor who, and the Bible for that matter, says that Christians should hate sin. So then it would mean, for all practical purposes, if we do not limit it to physical harm, that a gay person can claim that because a pastor says what preaches in the way he understands the Bible, that to be gay and to practice, to live a gay lifestyle, that that could cause then to a gay person emotional harm. And that could then lead to the imprisonment of such a pastor. Now, I want to refer the committee back to the fact that we are at all stages to balance freedoms and rights. I mean, we've talked about this at length during previous deliberations. So the argument I'm making is I don't think it is a proper balance for freedom of religion against the protection of the dignity of gay people to say that such a pastor must now face imprisonment. So that's where I went to the argument around, firstly, the possible penalties, and to say that if are we seriously contemplating imprisoning such a pastor, or are we in the balancing act saying that at least through the artistic or religious exercise, or in the case of journalists, the incitement must, if it is incitement, must then at least result in physical harm before the exemption is removed. So I hope that unpacks my argument a bit further. It's not about revisiting the options about harm. It's really about thinking in a practical way as to whether these exemptions will be the type of exemptions that will properly balance the rights religious groupings enjoy, as well as artists and journalists and academics for that matter. Thank you, Chair. I hope that explains it a bit clearer.
I still think that from generally a procedural point of view, Honorable Horn, the ruling I made on Honorable Nieuwort Dogan in a way does apply here, in the sense that we were going back to the first options, which was about, I think, harm. And we are going to still come to this one, which is on page 11, that I think what maybe we should be saying to the issues we have raised, that maybe the department should really be thinking about what you have raised, because we are going to come back to that, and maybe have a formulation that takes the balancing that you are raising into consideration, put it as an option, so that when we have in-depth discussions on the issues that we have raised, because we are coming back to that, then it would have we would have extensive discussions. But I think for now, we have to give them that space to come with a proper balancing, a proper formulation that does the balancing as you are articulating. Then other members then will have an opportunity to be able to respond. But I was going to suggest that we start from I think the first options, then we are going to come back to this.
Chair?
Is it Honorable Swart?
No, it's Deputy Minister, but maybe if Honorable Swart is on, but I'd like to speak.
Honorable Deputy Minister.
No, I just wanted to say, I see that the drafters have put in the word physical harm on page 11. It's on the screen. And so I then wanted to ask, and in particular to Mr. Horn, this then would be a requirement for all 4 of those partial exemptions, religious, media, artistic, etc. If that is put as an option, the word physical to go in, would that accommodate what he is concerned about? So through you, Chair, if we can ask Mr. Horn if that would address the issue. If that is put as an option, so that would need to be put as an option. Yes. I mean, if he's agreeable to it.
Yes. Honorable Horn?
Yes, thank you, Chair.
Okay, thank you very much. Honorable Swart?
No, Chair, I think I'll possibly just wait until we come back to the issue, but there was a bit of discussion around religious rights and that balance, and Honorable Maseka Jeli did make some comments about churches, which I think we do need to have a discussion about. But I don't want to enter that now. I think we can rather come back to this when we come back. Otherwise, it might muddy the areas. So I'll reserve that until we come back. Thank you, Chair.
Well, thank you very much. Thank you very much, members. Thank you for the guidance. Let's go to the first one.
Thank you, Mr. Chair. That brings us to the different options that are presented with regard to the definition of harm. And I'll be guided by the committee. Thank you, Chair.
Thank you very much. Members, I think we have 3 options here as they relate to harm. Can we have a discussion and sort of which will guide us as to which way is the committee tilting towards? I have Honorable Maseka Jeli, followed by Honorable Swart. Honorable Horn, in that order.
Thank you, Chair. I think I will go with option 1.
Oh, okay, you're done.
Thank you, Chair.
Thank you very much.
Chair, sorry for interrupting immediately, and I'm very rude. Please excuse me for that. But in option 1, we've actually got a choice whether reference should be made to objectively and substantially, or objectively and severely. So I would like maybe just to get an indication from the committee if option 1 is preferable, whether the word substantially should remain or whether it should be deleted in favor of the word severely. Thank you, Chair.
Thank you very much.
Just can you see the hands yet or not yet?
I can see the hand. I have Honorable Swart, Honorable Horn, Honorable Breitenbach, Honorable Jacob.
Can I just make a quick point, just following on from Mr. du Preez, and that is this issue of objectively and substantially or severely is in all the options. So it's not just option 1.
Okay. Okay. Without, maybe I think Honorable Maseko Jele will come back. Can I go to the next hand? I think it's Honorable Swart.
No, thank you, Chair. I would just to help on option 1, that we should go with objectively and severely. That would apply throughout, because it could be that option 1 is accepted and then it's a repeat of the same word. So I would, the option within the option, I would suggest that it should be objectively and severely. But I would go with option 4, which is, but there's a challenge there just with the wording, and obviously with the, and also you see the option of the deletion of the words social and cultural with the word deep or strong. So that would be the option that I would prefer, but deep doesn't really apply to physical. So I would like a word that is stronger than substantial. So that's why strong could be something, or gross could be something. So Chair, that I think this, we need to find, we're not far away from each other on these different options, and it is at the heart of the bill. And I think the sentiment I want to express is that we have a deeper adjective when it, excuse the pun, emotional and psychological, but physical. The word deep can't apply to physical. Physical in itself means anything. So it could be that if you have a, even on option 1, substantial physical, is that necessary? So maybe even a rewording, you could start with physical, because now you're even qualifying physical. So, Chair, my ideal option is with the word deep or something similar to that, and excluding the words social and cultural. But I'm sure we can, in our discussions, try to find one another on this, because we're in agreement with the 2 objectives, which is substantial or deep, and then severely at the end, or substantially repeated. So there's 2 lifting the benchmarks of what was a deletion of the word any, and then those 2 qualifications, and that we could look at the words, and then whether we include the words social and cultural or not. I think that's probably where we differ, but I hope that helps us as we have this discussion. Thank you, Chair.
Chair, before you continue, can I ask something, Chair?
Honorable Jele.
Yes, if I am allowed. I thought this thing, Chair, it was already refined for us, but I can see as Honorable Swart is explaining that, I think for us, I don't know if maybe I'm going to feel like that if I'm going to, Chair, choose an option where I still have to choose some wording, for example, the substantial, severe, objectively, Chair, I think it's a bit confusing to me. I don't know other people, because I can understand how Mr. Honorable Swart is now explaining the whole thing, Chair. Thank you.
Thank you very much. Members, we must also bear in mind that legislative drafting is very tedious. There will always be a back and forth in terms of trying to find the right balance. Because I think one of the issues that he has raised, I think which we would need maybe some guidance on, even from the department. I think the word deep or severely with the word physical, I'm not that much clearer. So I think let's allow the debates to ensue, so that ultimately we have the right wording that would not only that would also assist the courts in their interpretation. So I think it's good. Let's debate and refine and come back and refine. But I think we sometimes we would be confused as part of the process, But at the end of the day, let's ensure that we have a product that we can say we can be able to defend. I think our experienced drafters would also guide us. Honorable Horn.
Yes, thank you, Chair. Maybe also, again, firstly, in terms of as the Honorable Swart called it, the options within the options, I think we would also agree that the requirement must be that that it severely undermines. I think to revisit our earlier discussion, that I think personally, I believe that comes closer to what the court called deep, or the word deep used by the court, inquilani. And then in terms of the other options, I think if I heard the Honorable Swart correctly, actually advocated for then a combination of option 4 and 2. So from our side, Chair, we're still skeptical about the inclusion of social and cultural harm, in that I'm not convinced we all agree yet as to what that would mean. I raised that point previously. And for that reason, apart from then using the severe and not being against the deep in option 4, as the Honorable Swart indicated, option 2 would look closer to what we believe the definition should be. Thank you, Chair.
Thank you very much, Honorable Rittenbach.
Thanks, Chair. I've been covered by Honorable Swart and Honorable Horn.
Thank you very much, Honorable Yago.
Thank you very much, Chair. I think all these options are very, very confusing. If I'm going to agree with Honorable Maseko-Jele in that, I think substantially and severely and deeply is almost semantic. So I would say I would opt for option 1 and go for substantially, because I think that opens more room for interpretation than severely, because severely can be subjective, so I don't know if the courts can determine what is substantial versus what is severe or deep. So for me, I think it's like trigonometry at this point, because all these options are mostly aligned with one another. However, I'm leaning towards option 1 and saying, going with the word substantially. Yeah, thank you, Chair.
Thank you very much, Honorable Yago. Honorable Maseko-Jele, is it an old hand or a new hand?
No, Chair, I think I'm covered by Honorable Yago.
Okay, Honorable Maseko-Jele is covered by Honorable Yago. Honorable TM.
Chair, effectively, it's a decision of the committee. I think the issues from the hearing, well, I think does everybody agree? Well, no, it's yes, the Judge Majid used deep. I'm not too sure what, I mean, yes, he's a constitutional court judge, and that was the judgment of the majority. But as we've said, there wasn't a reading in. Deep is, I think, intense or extreme in terms of a dictionary definition that I looked up. I think everybody I think the drafters were saying that substantial is something they are more familiar with. So just to make that point. The other main division is a question of whether the DA, the ACDP want to limit, not to include social or cultural, or I don't know if it's economic, that's also not in option 2. So they want to limit the kinds of harm that are caused. The issue of social harm was referred to in Kumalo and referred to in Kwelane as not affecting or undermining social cohesion. So there is already an element from that. There would be an issue of economic harm in that something you say against a group, somebody, a shop owner who is of a particular nationality or of a particular religion, can affect them economically, can cause them economic harm, because then people of other groups won't go there. So that would be my argument for including economic harm. Yeah, so basically just that's that point. So we would prefer the issue of option 1, with it being because there's got to be substantial harm, and that harm has to undermine the human dignity of the targeted groups. And so it's a question of objectively, which is then it's not linked to that person, but the court, it's not subjective. And that also then has to be substantially undermining. But Chair, it's then ultimately a political decision between the parties.
Okay. So there's option 1.
But I would suggest that you maybe deal with it firstly. Is it substantial or deep? That's the sort of question. Is cultural, social, cultural, and economic included or excluded? And then the last issue would be the substantially or severely undermining. Those seem to be the 3 areas of difference.
Mr. Chair, I apologize profoundly, but I would just like to, and the deputy summarize the 3 issues around the definition now, but there's one technical aspect that I would like to bring to your attention. If you look at, for example, option 1, we use the word substantial and then emotional, etc. Detriment that objectively, and then we use substantially again. Technically speaking, Mr. Chair, the word severely might be more appropriate without, or rather deleting the word substantially, because then it's a duplication that might confuse the whole meaning of the definition. Thank you, Chair.
So you start with substantial, emotional, and then towards the end, instead of again saying substantial, you say severely undermines the human dignity and the targeted individual groups. That's what you're saying.
I think that would be technically more correct, Chair. Thank you.
Yes, under option 1. Honorable Breitenbach.
Thank you, Chair. I was going to raise the point that Mr. du Preez has now raised. And again, refer to paragraph 154 in Kwelane, where the court says harmful can be understood as deep emotional and psychological harm that severely undermines the dignity. So they like the word severely. I quite like the word severely too. Thank you.
Thank you very much. Honorable Swart.
Chair, I think maybe we can then, you've got that if we are in agreement with Mr. du Preez, just to deal with the option within the option, using the word severely, that would help then us as well formulating, and then at the end of the day, we've got 2 options. Option 1 with the word substantial and severely, and then we could have another, the option combining 2 and 4 would be, instead of the word substantial, you would have deep, or a synonym of deep, intense or extreme, with the second part would be severely, and then excluding social and cultural. I think that would be the two options we could probably capture now, and then at a suitable time when we've been through everything, we can come back and then take a final decision on that. It might be possible. I don't know how you, Chair, you want to do, whether you wanted to finalize that right now, but maybe let's just look at the two options, because as I say, they are not too far apart. And at the end of the day, it seems to revolve around the difference between the meaning of the word substantial versus deep, the inclusion of cultural and social. I'm not sure if Mr. Horn has got a problem with economic. I don't have a major problem with that. And then we are in agreement about the word severely. So I think once you've narrowed it down to that, then I think we're pretty close. We can delete the other options.
Members, can we take that, and then tomorrow, then we will do the final decisions on each one. For now, we are narrowing, so we'll have option 1 and the option 2, which combines option 2 and option 4. And then tomorrow, when we come back, then we'll be taking final decisions. So I think let's continue to narrow each options as we go, but tomorrow we will be making the final decisions. Will that be in order?
Sorry, Chair. May I just interrupt quickly?
Okay.
I just would like the department to perhaps just, for my indulgence once more, just expand to me what would be social harm, an example of social and cultural harm, so that we can make an informed decisions on those two terms of what would be harmful socially and what would be harmful culturally.
Okay. Deputy Minister, with your team.
Can I ask the officials to start? I'll then add.
Okay.
Tough question.
I will always start with you, DM, as the leader of the delegation. It does not mean that it should be you. So
it's a nice shifting. It's a
no,
tough question.
No, I have an answer, but I'd like to hear them first.
No, sorry, members. As a matter of protocol, he is the leader of delegation, so I would always say DM, but it will be up to him if he delegates it to the technical staff. But because he's here, he's the leader of delegation, protocol-wise, we have to defer to him, and then he decides how he wants to deal with it. Either he delegates it to officials or he answers it himself. So Mr. Dupree and Ms. Botha.
Thank you, Chair. And I think I'm in checkmate now at the moment, because my the deputy and the rest of the team haven't had the opportunity to really thrash this out. So I'm going to go out on a limb, and I'm going to give you a personal opinion. I am always uneasy to speak before my deputy, but we've got the proposed definitions of culture and social, and it is debatable whether it is necessary to define, because the only thing that these two proposed definitions do is to define terms in another definition, and it's weird, but it happens a lot in legislation. But I would say that even if I suffer social or cultural detriment, it might just as easily qualify as emotional or psychological detriment, because it's the impact on me as an individual forming part of a group and the impact on that group. So emotional, there's detriment. Psychological, there might be detriment. I'm now going to hand over the axe to, or the hot seat to Ms. Botha if she wants to add something. Thank you, Chair.
Ms. Botha?
Thank you, Chair. Thank you, Mr. De Bruyne. I have been trying to speed read a 150-page report, which we referenced in our research note 2, which we prepared for the portfolio committee. And it speaks to an analysis of hate crime legislation, which was conducted across sort of 5 or 6 countries. And it speaks to different kinds of harm, including social harm. I don't at the moment see a reference in that document to cultural harm. But sort of if I think about what I have read about studies done on hate crimes and hate speech, and sort of the underlying sort of academic reasons for needing such legislation, there is a recognition that there is harm to society which is caused as a result. And I'm just sort of trying to speed read through this quite heavy document. If I may, I might just hand over to the next person who'd like to deal with this while I speed read. But there is an excerpt from what I'm reading this report, social/behavioral harm, which is recognized as a third type of harm that may result from hate crime, is social harm, or as other academics define it, behavioral injury. And the argument here is that victims of hate crimes are more likely than victims of parallel non-hate crimes to change their behavior in response to an incident, because they're worried about and wish to avoid repeat victimization. And that report then also references studies which have been done to show that there is social harm. Thank you, Chair, and I'm happy to share that document should you wish, or should it be helpful. Thank you.
Chair, can you see my hand?
Yes, you can proceed.
Okay, no, let me come in then. The issue is, as I would understand it, I mean, the bill came with social harm. It didn't come with culture. That was cultural, rather, which, cultural harm. That was a submission, public submission, which I think the committee had then wanted to take on board. I think what's important is also that all the options are regarding undermining the human dignity of the targeted individual or the groups. And the issue would, for me, be that in society there are social groups. I would see it as, with a broader definition, maybe the definition of social that we have here is not broad enough. But you can say something that offends, let's say, lesbians as a group. You can say something that offends gay people as a group. You can have say something that offends Muslims, Roman Catholics, etc., etc. So that is the issue of, for me, of what social harm is. It's upsetting everybody in that group because of what you've said. It can also be race, in terms of something is said that upsets Black people, not just the individual who the thing was said to, but all or most Black people get hurt, or sorry, harmed by what has been said. And then just also to draw the attention to Kwelane, saying we are following it a lot. They referred to 3 types of harm, the reaction of persons who read the utterances and are inclined to share those views and encouraged by them to shun and denigrate and abuse the targeted group. That's the first kind of harm. Second, the type of harm experienced by the targeted group, which includes demoralization and psychological hurt, and the harm caused from responding in kind, thereby creating a spiral of invective back and forth. And third, harm to the social cohesion South African society, which can undermine our nation building project. So that for me is an acceptance of South Africa is a country of diverse people, formed into different groups, many different groups sometimes along many different lines. And it would be harm to that particular group would be social harm. Cultural was then added in, and that's trying to sort of define it. And again, for me, I'm not sure whether we need culture and social. But there is an attempt as a definition of that. Yeah, but social, I think we need. Thanks, Chair.
Thank you very much. So far from the department side, there is no strong motivation for cultural.
Chair, no.
Okay. Honorable Breitenbach.
Hold hand, sorry.
Thank you very much, Honorable Swart.
Thank you, Chair. Yes, I think we've made progress just to understand that there's no need for culture. We would submit that even social, it's too broad. And I do appreciate the DM saying we are following Kwalani, and I've done that myself, but we need to remember that Kwalani dealt with civil remedies in terms of Papuda. Here we're dealing with criminal remedies, and a higher threshold, a higher bar is required. And that's why even on option 1, you've got the insertion of substantial and possibly severely undermined. So that qualification is there. I think the examples that the Deputy Minister gives obviously must be seen in the context of the definition of harm, such as substantial and severely. When he says you can say something that offends gay people as a group, obviously it must result in substantial harm, because as we know, that has been allowed in terms of the Constitutional Court. And what we are dealing with here, as I said at the beginning, is that hate speech, as the Constitutional Court has found, goes beyond mere offensive language. And it is an extreme detestation and vilification. Expressions which are, and I'm quoting from the judgment, are merely hurtful or are insufficient to constitute hate speech, and even offensive speech is protected by freedom of expression. And I think we all accept that. That's why we've got the qualifications in the harm definition. So I think we're making good progress. I would agree. I just take it the one step further to say I don't think there's a need for social as well. Given what Mr. Dupree said, we're actually dealing with emotional, psychological, and then the issue relates to economic as well. It's covered by those already. Thank you, Chair.
Thank you very much, Honorable Mulder.
Thank you, Honorable.
Honorable has a hand up as well.
Yes, I've seen, I've noted, it's Honorable Mulder, Honorable Yako, Honorable Nieuwoudt-Tochen, Honorable Horn in that order.
Thank you, Honorable Chair. Now, I was largely covered by Honorable Swart. I just want to ask a clarity question to the Honorable Deputy Minister. As far as boycotts concerned, for instance, where economic harm could be caused, would that, in other words, imply, for example, that Christians may not be allowed to boycott businesses that profit from the sex trade, for instance, because it can cause economic harm? Shouldn't they have the right to do it? It's just one question about possible unintended consequences, or is that exactly what is meant? For instance, this situation becomes entirely arbitrary, where boycotts are then allowed and which not. For instance, I think the ANC used boycotts like this in the struggle against apartheid, where a certain group of people were targeted with boycotts. So if I could just get a clarity, just a clarity-seeking question. Thank you, Chair.
Thank you very much. Maybe let's first take all other members before we go to Honorable DM or his team for the response to Honorable Mulder. Honorable Yago.
Thank you very much, Chair. I think having asked the question and having received the answers from the department, I think that even they can't define clearly what is social and cultural harm, which for me informs an opinion that it should not be included as options if we can't clearly define what it is, because I mean, the EFF could write, for instance, about Nazis and then, or white supremacy for that matter, and that would then be cultural harm for those who identify as white supremacists. Do you know what I mean? It's so wide in that you can't clearly define it. So basically then we can't put it as a context for our bill because we have no explanation of what is social harm and what is cultural harm. And also I think that instead of dividing substantial and severe harm, we should then say objectively, substantially, and severely undermines should then be an option, because then it covers all three definitions, which for me are sort of mean different things in different times. And I would strongly want them to be included as an option. Thank you, Chair.
Sorry, can you repeat that, the last one?
The last part I'm saying, I'm thinking that we should not split or have to choose between substantially undermines or severely undermines. I think that it should say that is detriment, any of harm that is emotional, psychological, physical, economically detrimental, that objectively, substantially, and severely. So I'm leaning away from us dividing substantial and severe, because substantial is substantial in its own way. Severe is then deep, severe harm. So I think those three should not have to be divided. We should just say objectively, substantially, and severely undermines, or objectively, substantially, or severely undermines. That's my opinion as to a definition that would then cover everyone who feels harmed by an utterance.
Okay, thank you very much, Honorable Nivot Johan.
Thank you very much, Chair. Just because the department wasn't able to automatically give a response to the question, that still does not mean that social and cultural harm should be left out. It does exist, it does happen out there. Cultural and social harm does happen. For example, the department says that cultural is the sum total of behavior, beliefs, values, and symbols of an identifiable group of persons, and then moving forward, transmitted by one generation to the other, identifiable to the group. We have different cultures of dressing, cultures of eating. For example, at one school, 2 girls were made not to wear pants or don't wear pants. We know that Muslims have a particular way of dressing that includes, a top and pants, and they were not allowed to wear that. And that is harm. Harm was done to the children. And in South Africa, some women wear scarves, and in some in places of employment, their uniform does not allow them to wear scarves. So there are many examples out there. Maybe these things do not happen to us, but they happen to other people. They happen to other people's cultures or other people's societies. So we do need to maintain these two terms. Thank you, Chair.
Thank you, Honorable New Vote, Drohan. But we must always bear in mind that whatever we do here, we're dealing with something that ultimately will result in a criminal offense. Maybe some of them, they can easily be dealt with in a civil process, but we must be able to say whatever we put here in a criminal proceeding, will it be able to stick? Will it constitute what would be really a crime? I think that is what we should be always having at the back of our mind. Honorable Horn.
Yeah, thank you, Chair. And at the risk of getting sidetracked and entering into debates that not really assisting, I want to firstly say that I think with respect the examples given by the Honourable Nivo Drugen is not necessarily speech examples unless one wants to see the school governing body making the rule and publishing that rule then as hate speech, which I don't think is what we intend to do via this bill. It might be that what the Honourable Nivo Drugen describes is discriminatory practices, which of course there's other legislation in place to deal with it. And even when I say that, there's of course also the argument around whether schools should be allowed to determine their own culture, so to speak. Yeah, but as I said, that was at the risk of getting sidetracked. Chair, around social harm, I wanted to make the point that I think we are at risk of elevating social to being part of the definition, whilst historically the social harm, so to speak, or the social change in behavior as referenced by Ms. Botha, has been used ultimately in order to settle on groups that must be afforded protection through hate speech legislation. And I think that is a slightly dangerous thing to do. In the past, we've referenced the requirement globally that in order for a group to qualify for protection under hate speech legislation, there must be a systemic pattern where speech aimed at that group ultimately also has the effect of that group or members of the group when they receive the speech to change their behavior or their social behavior. And I think that's well settled. Whether that necessarily then justifies it to be included in the harm, I don't know. This could then be sort of in a circular way, both the definition of harm and the groups self-reinforcing one another, and I don't think that was ever the intention about how we should go about either the groups, or in our case the grounds or the characteristics, or the definition of harm. So to cut a long story short, Chair, I agree with those colleagues who have argued that given the fact that there's not been forthcoming real examples of social and cultural harm that needs it to be included in the definition, and B, the few examples that have been given are all closely linked to other forms of harm. I think Mr. Dupré himself pointed out that emotional, psychological, and harm specifically would then be closely linked in any event to social and cultural harm. That we tighten up the legislation also, or the definition by removing them, also specifically in light of what the Honorable Swart once again reminded of us all of very aptly, and that is that we are dealing with criminal legislation and not necessarily dealing with hate speech within the civil or non-criminal sphere. Thank you, Chair. You're still on mute, Chair.
Thank you very much, Honorable. Is it Honorable Nivot Rohan?
Maseko Jele, Chair.
Oh,
If I'm
Honorable
correct.
Nivot, yes, can you
Sorry,
lower
Chair,
your
it's an old hand.
yes, okay. Honorable Jele.
Thank you, Chair. Chairperson, I just want to propose that this matter, it should be dealt with the same manner with the one that we have just dealt with now. We should not conclude on it because, Chair, we must also give the department another chance, maybe come back tomorrow as we will still continue with this matter because I think I hear other colleagues, Chair, and I also hear where you are coming from, that maybe we can and take it to not criminalize it, Chair, but also consider it maybe on the part of civil. But I think that we did give some reasons last time when we were talking about this issue, the reason why it is the department decided to go and even come to the point of giving us those definitions. So I was saying, Chair, maybe we should not hurry in concluding on this matter. Let's give it another chance and talk about it tomorrow so that we can also make sure that the reasons that we bring forward, they convince probably even our colleagues may look into this matter differently. I don't know if maybe it's possible, Chair. Thank you.
Thank you very much. Members, I'm just choking. Can you just give me 2 minutes?
Get water, Chair. Yo.
members for your indulgence. No, Honorable Maseko Jel, I think we do note your way forward, but I think we'll come back to it after we have heard also other members. Honorable Swart.
Chair, very, very briefly, I think the difficulty, and I've got no, I support the department having a relook at this, but the difficulty is given any practical examples that will not be covered by what is already in the bill. And I think that's why Mr. Dupree says, you know, we don't need, and I agree with him, cultural, because it's covered already by emotional, psychological, and I would even submit that we don't need social as well. And if you look then even at the example with the greatest respect that the Honorable Nevo Druchen gave, that would fall under civil remedies, as you, Chair, correctly pointed out. But even if there was to be a level of hate speech in the example given, that would fall under one of the grounds, which is religion. And so we've got to contextualize this with the whole bill, where an issue where we are saying now it could be a social issue or cultural is already in terms of the grounds or characteristics, those elements are covered there. So I would think that, just to conclude, I again re-emphasize that I don't think it's necessary, but let's give the opportunity to the department again to look at it. Thank you, Chair.
Chair.
You are next, Honorable DM.
Yeah, no, thanks. I've had my hand up for some time and people have been speaking more than once, but just on the issue of social harm, where this I think is coming from is if you look at the South African Human Rights Commission versus Khumalo case, which was a issue where Mr. Khumalo had been deemed to have insulted Jewish people, and the court came up with three types of harm, which was then referred to in Kwelane, but specifically they said this harm to the social cohesion in South African society caused by either or both of the former two forms of reaction, which on a large enough scale undermines the nation building project. Remember, there wasn't a definition of social, but that's what it basically is. If the social groups, which would be very wide, maybe they are wide enough to include cultural groups. But if something is said that offends or that insults, harms Muslims, Tsonga people, Venda people, Greek people, Roman Catholics, is that not social harm? It's undermining the social fabric of society. Those are social groups. So I think that is what we were referring to as social harm. I think it's difficult, whilst yes, both Khumalo and Kwelane were about Pepuda, they're talking about harm, and one is then saying that we don't recognize social harm if we don't have this provision. So I just wanted to particularly, I think the issue was as far as cultural, we're not so sure about, because we'd seen social as more all-encompassing. Remember that this is all, and this effectively also to answer Mr. Mulder on the economic harm, you've got to basically, it's got to be the grounds that have to be followed, which we're going to be coming to, and there are different options. So yes, if you, for example, say that all businesses owned by Muslims, all businesses owned by Malawians must be boycotted, that may start going into hate speech relating to if we have a religion and a race or nationality as a ground for hate speech. It would not include some members of some far right-wing group. Which group are you talking about under the ground? on the grounds issue. And that's why we've also gone for a more limited ground. So yes, Mr. Mulder, in the past, we did have racially based consumer boycotts, effectively boycotts of white businesses. That was at a particular time in the struggle. And that was particularly because we were not a democracy, only white people had the vote. And that was an effort to pressurize white people, and a successful effort in many cases, to pressurize white people into getting the government that they elected, the National Party government, to concede to particular things and reduce repression. That's now in the course of the struggle. So, Chair, I don't know if that answers it. I mean, we can re-look at it, but I would want to say that we do keep social. We can look at whether, and that can be an option one. Mr. Swart and Mr. Mulder and the DA can go for option two where they don't have it. I think though Mr. Swart was supporting economic harm, so maybe there's a different ground, but we can look at the issue of whether we do need cultural. But I would say I think we do need social. And then the issue of Ms. Yako's point of substantial and severely. Yeah, I mean, that's something we can look at, having both. One, I think, would have thought that they were more synonyms. Mr. Dupree has said that you have substantial in the beginning because that relates to the detriment must be substantial. And the second requirement is that it must undermine, an adjective to undermining the human dignity, that being substantially or severely. Mr. Dupree's thing was, it may not be good, even though they're different concepts, to have substantially twice, and therefore you have severely. But that's something I think the department can consider and come back to you tomorrow on. Thanks, Chair.
Mr. Chair, I apologize. Before you recognize Ms. Botha, I would like to immediately respond to what the Deputy Minister just said. Is the proposal is that the detriment must be objectively and substantially and severely undermine the human dignity. It's the test is just simply, if you want to retain both words, substantially and the word severely, there must be this disjunctive between substantially and severely. But I would strongly recommend, Mr. Chair, that the word substantially rather be omitted from the options. Thank you, Chair.
I was muted. Honorable Masego Jele, is that an old hand or a new hand? Honorable Jele? Honorable Botha?
Thank you, Chair. This just goes to the point that the DM was making, and I was mainly covered by him, but I just wanted to come back because I have waded through that 150-page report and I found a quite relevant excerpt on social harm. And if I may, I'd like to just read a bit of the excerpt.
Sorry, Ms. Botha.
Yes.
I think you are under a lot of pressure because you are speed reading whilst you are expected to give an answer now. I think, to be fair to you and the entire team, what we need to do is that just go and read properly and come back tomorrow, especially on the social, because I would recommend to members that quite clearly no case has been made on the cultural, because we want also to use our resources in an efficient manner, that I think what we need to be focusing on, there is no dispute generally by members on the economic side, on the economic harm, physical. There's generally an issue about social. Other members strongly believe that social needs to be included, others do not. That maybe the department, when you come back tomorrow, you should have, in fact, you should look at this social, and you can generally take us through that social. But I would recommend, just for the sake of progress, that we have, in fact, there is no amount of information that justifies for now the inclusion of cultural. So let's come back to these two options. In fact, we've got two options now. It's option 1 and option 2, which combines 4 and 2, as it was proposed by Honorable Swart, that tomorrow we will start having that debate. Hopefully by tomorrow we will be able to find one another, but we are much more closer to one another than before, and that the department just look at these options one more time, including further research on social. Will that be in order, members?
Fine.
It's fine, Chair.
Thank you very much. Let's proceed.
Yes, Chair.
Thank you, Mr. Chair. Now it's a question of the committee having to decide whether the definitions of, well, depending on the final decision on social, but whether the definition of at least culture and then possibly social be included in the bill.
Yes. I think what I would suggest for now is that let's leave it, and then the discussions in tomorrow would inform the way forward on the two definitions, as to, because I mean, you can't include what you would not be able to use. So let's allow the discussions tomorrow to ensue, and then thereafter we would come to the decision on the two definitions.
Thank you, Chair. Then the next portion of deliberations will be on the definition of characteristics. We have the option of excluding age, and then also the option of including race or skin color, and then the option of excluding language, and the options of excluding occupation or trade, and then political affiliation or conviction. And that is with regard to characteristics, and those apply to clause 3, the hate crimes provision.
Thank you very much, members. Are there any comments there? Honorable Jelle, I take it that is an old hand. Am I correct?
Yes, it was an old hand, Chair. I'm still looking at the thing again. Thank you,
Thank
Chair.
you very much. Honorable Yako, I take it it's a new hand.
Yes, Chair, it's in your hand. I would say that I don't have any issue with the exclusions and inclusions. Yeah, and I think on the issue of skin, I think Honorable Maseko Jelle has really expanded and is truly passionate about the issue of skin color. So we'd be remiss not to indulge and include that in one of the characteristics, and that's my submission.
Thank you very much. Any other comment? None. Can we
Mr.
proceed?
Chair.
Honorable Horn? Honorable Horn?
Yes, yeah, thank you, Chair. I think from our side, without repeating all of the previous arguments around these characteristics and remembering that there must be an underlying crime, yeah, maybe the Honorable Breitenbach can explain it more passionately. I think we remain worried that this will, on the one hand, possibly only symbolic in the sense that it might prove near impossible to really prove motivation. And on the other hand, I don't think the issue previously raised about whether one could be precluded, if you are the prosecution services, from using these characteristics possibly in arguments about aggravation in sentence, if you have not proved it as part of the crime itself. I don't think that specific question has been answered with finality. I know the Deputy Minister offered the opinion that in his view that there would there would not be a bar against doing so. From our side, I think for record purposes, we remain at best skeptical, and would argue that it is something we should take careful advice on before we ultimately decide on that. This, of course, quite possibly has more to do with the way in which the crime is defined, but it is also to an extent linked to the characteristics. Thanks.
Thank you very much. Honorable Deputy Minister, can I take you at the end so that if there's a need for you to respond, you can?
Okay, that's fine, Chair.
Thank you very much. Honorable Swart.
Chair, no, I'm largely covered as well by what Mr. Horn said. There are a bit of concerns, but I think we need to just clarify that there are different options. We're just dealing with the first. Characteristics deals with hate crimes, and then there are options where when we're dealing with the grounds, which deal with the hate speech aspect, as I understand it. And so I think, yes, there are some concerns from our side as well, but as we go through the different options, I think we need to try to bring it down to how the different options are they correctly captured. But I think the option 3, I think, is the more preferable one from our perspective. But again, I'm open to discussion and to try to take the matter forward, bearing in mind what Honorable Horn said about the prosecutorial difficulties that Honorable Breitenbach pointed out before. And that, I think, is a prime consideration. Are we not placing a higher burden on the prosecuting authorities? And without reopening, we are right at the end of the process, but it would have been good to possibly hear whether her sentiments after many, many years of prosecutorial experience are shared by the MPA as well. We don't want to place a higher hurdle whilst fully appreciating the need for prosecutions for hate crimes. That's what we're dealing here. So, Chair, that's my input on the hate crimes aspect. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Breitenbach.
Thanks, Chair. Yeah, look, we need to bear in mind, and we tend to forget it going through these definitions now. We need to bear in mind that there has to be an underlying crime, without which none of this will come into play. And I've expressed the view before, and my view has not changed. And it's just a cautionary view that that we are placing a very high, almost impossible burden on prosecutors by expecting them to, in addition to the elements of the underlying crime, prove these additional elements that are more often than not only discernible in a state of mind, which is notoriously difficult to prove. And that's just one portion of the problem, because I strongly disagree with the Deputy Minister on the point of argument in aggravation or mitigation. If in the proof of the underlying crime, you have not, for want of a better phrase, dragged in these elements, you could argue very strongly in aggravation of sentence about motivation, because there's a marked difference in the burden of proof in what you can argue in aggravation of sentence and what you argue in a trial situation. But if you have failed to prove these elements in your prosecution, and you've only managed to secure a conviction in the underlying offense, you will not be allowed to argue these elements again in aggravation of sentence. The court will simply say, what do you think you're doing? You didn't prove it. Move on. You can't rely on something you haven't proved. It's unthinkable to think that you can do that. The prejudice then would be so great that it would absolutely give rise to probably a successful appeal. So I'm saying that the burden that you're placing on prosecutors is already overstretched and under-resourced and under-experienced and under-trained. The burden that you're placing upon them is an impossible one, and that we should seriously consult with and I don't dispute that the National Prosecuting Authority has been consulted. I don't know who at the National Prosecuting Authority was consulted. But if you go and speak to prosecutors, you have to prosecute these things every single day. They will tell you of the great difficulties that they experience. And I want the committee to bear that in mind. Thank you.
Thank you, Honorable Breitenbach. Honorable Maseko Chele.
Chair, Sugan lapha. Hayibo, don't dare to speak.
Honorable
Hayibo.
Chele, you are live.
Hear me?
Yes, we can hear you.
Yeah, I
Honorable
think she
Chele,
muted herself.
yes, can we jump you? We'll come back to you.
Anyway.
Honorable Chele, we'll come back to you. Honorable Mulder.
I'll try to set this one.
Thank you, Honorable Chair. No, I would ask that this committee listen very carefully to what Honorable Breitenbach just said, and that we should really consider it in the work that we're doing. Although
I don't know whether it was.
Although I'm not a member of this committee, I appreciate the opportunity to contribute here. And I'm also concerned on behalf of the FF+, who said from the way start that I'm of opinion that we're actually in a process of double legislating and putting extra pressure onto our justice system. So if we are busy doing the work that we do, we should really consider the practical implications of that. And I want to stress again that we should consider what Honorable Breitenbach just said, that I'm in support of that. Thank you, Chair.
Thank you very much, Honorable Mulder. Honorable Maseko Chele. Honorable Jelle?
Thank you, Chairperson. Can you hear me now?
Yes, we can.
Yes, thank you, Chair. I was, Chair, pleading with the committee that let's not have those options on those characteristics, because the issue of age, Chair, we did speak about it. There are really a group that, if we leave the issue of age, is really going to be dealt severely with in terms of their rights. We did speak about the issue of the old people, how they are treated and how they are killed, Chair, earlier. And we gave that as a motivation that even if, Chairperson, in such cases, like the very same language you are saying, some of our colleagues are saying it will be difficult to prove, Chair, but it must be proven in court, because obviously there will be an old woman that will be killed somewhere down. I won't say, just to make an example, I'm not saying in Limpopo they are killing people, but I'm saying there will be someone that will be killed old because of this person is old. And you know, when we grow, our faces, our status changes, Chair, physically. And now there's this culture of killing those people. So I'm trying to say, Chair, I would agree with the view that let's leave these matters to the court. Let everybody who feels that is aggrieved in terms of that use this as a motivation to bring the case to the court. Let's, it will be a very painful for us to say, we should have done it. We should have put the issue of age here. Now this is happening, and we have no way. It is taken lightly, and people are dying, and we'll have left that. So hence I was saying, I agree with leave the skin color, leave the issue of age there, and the language too, Chair. I think the department did motivate about that. Thank you, Chair.
Thank you very much, Honorable DM.
Thanks, Chair. I'm just having to charge my iPad, so that's why I'm not putting the camera on.
Okay.
There's a number of issues that have been raised. Let me just maybe start with Mr. Swart, who I think was discussing, because he was talking about option 3, discussing the grounds, which we're still going to come onto. So I'm not going to discuss the grounds. The grounds relate to hate speech. These are the characteristics for a hate crime. Let me start with Honorable Breitenbach, who doesn't want the bill. He thinks the existing law is fine. The requirement to make it a hate crime is something you've got to prove beyond reasonable doubt. If you don't prove it and you're able to prove the underlying crime, then the person will be convicted of that underlying crime, but not as a hate crime. Evidence in mitigation or aggravation is weighed up, as you know, on a balance of probabilities, not beyond reasonable doubt. So it's a much higher, a much lower level of proof, quantum of proof that's needed. And the court can say, yes, you didn't prove beyond reasonable doubt, but we will accept on a balance of probabilities. We want this legislation because we want to discourage people from committing hate crimes. Other countries around the world have legislation on hate crimes. The other issue, maybe just to use an example, Mazelsport. The people are charged, the accused are charged with assault, and they're charged with attempted murder. I think the attempted murder related to one of the men trying to push a child's head underwater. But if you take the others who are just fighting, it's assault. Assault is not a particularly serious crime.
Yeah.
If we have this as a hate crime.
Sorry, Tia.
Yeah.
Jelle, can you mute yourself?
My apology, Chair. I don't know. It keeps on bringing it.
If we have the hate crime legislation, this is the hate crime legislation then those people could be charged with assault as a hate crime because it appeared to be racially motivated, what they were doing, which makes it a more serious crime. And that's the need for this legislation. Then as far as the different categories, I'm quite surprised that there's an option, there's a aversion to language as a characteristic. You know, I think the one picked up a sense from Afrikaans-speaking people that they were being discriminated against, but language becomes a factor if there's crimes committed over a dispute over language. Yeah, so
Honorable Velma, can you text Honorable Jelle that she's disturbing the meeting?
Will do, Chair. Will do.
Thank you very much. Sorry, Deputy Minister.
no, that's fine. I've largely finished. So look, the issue of Honourable Breitenbach is bringing back the question which we've been through before of not wanting the bill, and we know she doesn't want the bill. But we want the bill for those reasons. It may be politically that the DA doesn't want it. I can understand why the FF Plus doesn't want it. But we've gone into that. And yes, is there not a difference between beyond reasonable, well, there is a difference between the quantum of evidence needed to establish a case beyond reasonable doubt, which would be to prove that it is a hate crime in court, and balance of probabilities, which would be under aggravation of sentence. With having this bill, we will make crimes that are committed on the basis of race, on the basis of religious discrimination, a lot more serious, when they could have been originally more minor crimes originally. So, Chair, that's it. I mean, I think that it's a pity that members didn't talk about opposition. Well, some members did, but support or opposition for some of the characteristics. Honourable Maseko Jele has spoken about the issue of age, because that was an option to exclude it. Honourable Yako has spoken in support of skin color. I think Honourable Maseko Jele has spoken in support of language. I'm not sure who's opposed to language. And occupational trade, as we've said, people get attacked on the basis of their occupational trade. Bus drivers, Uber operators, Uber drivers, hawkers, that kind of thing. And then political affiliation or conviction. There is unfortunately political intolerance, and people get attacked, assaulted, killed because of their political affiliation. And those are we need to be hate crimes. I think the rest are there's agreement on. Thanks, Chair.
Okay. DM, there was that issue raised by Honorable Jelle on the issue of age. Why is it excluded?
Chair, that's an option. I think the issue to look at, for the committee to look at, is, are the crimes committed against people on the basis of their age? they're broadly belonging to a particular age. Will there be a tax on people because they're children? Will there be a tax on people because they're youths, young people? Will there be a tax on people because they're older people? That's basically the issue that the committee has to look at. But remember that none of these characteristics are all in the alternative. So I would also argue that adding characteristics shouldn't be a problem, because it may not be relevant. It may never be used. So yes, there's been an issue of, would there be a crime committed on the basis of skin color? That you want to make a hate crime because the person's skin color was an aggravating factor. I would have thought yes, there would be, but even if it's never sort of comes up, there's no harm having it there. So, Chair, on the issue of age, it's an option for the committee, which when the committee finalizes its final position on the bill. But I think that those are the questions one needs to look at, as including age as a characteristic.
Okay. I think we can move to the next one. That is the grounds.
Chair.
Honorable Horn.
Yeah, please, just please allow me to respond, because I mean, it obviously can't stand for the Deputy Minister to speak on behalf of other members. I think we've been very clear from the start that while we see the necessity for hate crime legislation, we're rather in favor, and the Deputy Minister now again today acts as if that's not true, hate crime legislation, of formalizing the possibility, also used in other countries as part of hate crime legislation, of using the possibility to rather list the let's say the characteristics or grounds on which hate crimes or it could become relevant during the imposition of sanction that there has been a hate crime. So maybe just to clarify it, internationally, there's two options. The one is that you, as this bill tries to do, say that there is a crime, it's informed or motivated by hate, and therefore there's it then is a hate crime. The other option, which many countries use with great success and which we are in favor of, is to say there is a crime, and then when we impose a sanction on the criminal, the court take note of the fact that this was motivated by specific hatred, and that a harsher penalty is then to be imposed. So the mere fact that we're in favor of rather the second option doesn't mean that we're not in favor of dealing effectively with hate crime. Our objection and our reservations about the burden that is going to be imposed and which might defeat the purpose of the legislation in many instances remain standing. And then lastly, let me again say that I find the argument that we must include whatever we want because maybe it will never be relevant and never be used is cynical at best and leads to sloppy legislation at worst. I mean, it can't be that a responsible legislature act with making criminal laws and then just think up all possible scenarios. That's not how criminal legislation should be working. Criminal legislation is supposed to be reacting to what is already prevalent in society. So unless each one of these characteristics can on its own stand on its own legs based on a systemic manner in which people on the basis of these characteristics are targeted, it will not, in our view, ever be proper for the legislature to include them. Thank you.
Chair, may I respond?
Thank you very much. DM, can you respond after Honorable Swart?
Okay.
No, Chair, very briefly, I just wanted to inquire as we've been going along and we've suggested amendments, and I appreciate what the department has done, but has there been consultation with the NPA? And again, we're at the end of the process. I'm not suggesting any delays or anything, but just to meet the concerns of the Honorable Breitenbach from a practical perspective. To what degree has there been ongoing consultation with the NPA, given the concerns that have been expressed there? Maybe I can just be enlightened in that regard. Thank you, Chair.
Thank you very much, Deputy Minister.
Thanks, Chair. Chair, look, maybe Mr. Swart wasn't there, but as we've said repeatedly before, we have been consulting the NPA at the senior level, at the national level, the NDPP, the DNPPP. So we have been doing that. We've told the committee that on a number of occasions. So I hope that issue can be put to bed. And even Ms. Breitenbach seems to accept that, but I think her argument is, well, what are the junior prosecutors saying, or the people who are actually prosecuting? But that's also up to the national people, to the senior leadership of the NPS, to, we presume they represent everybody, or they're speaking for everybody. But can I please put that issue to bed, because it does keep getting raised, and we have answered that on a regular basis. Honourable Swart, I accept you may not have been there when those responses were given. Then on Mr. Horn's point, look, you can't have a hate crime without hate crime legislation. So yes, you can find somebody guilty of the crime of assault, and you can accept as an aggravating factor that the assault was caused by dislike for the person's race because they were Black. But you haven't made that into a hate crime. You can only create a hate crime by doing what we're doing here. So I'm not quite following what the DA's position is, or how they're trying to have it both ways. You either have a hate crime or you don't. And that's the point. And I think that there's a political difference on, and we must just accept that. But I mean, it works both ways. So Mr. Mulder is, I'm sure, very concerned about his constituency, which I think is more white Afrikaners, and because very often some of these racist incidents, or many of them, are propagated by a particular group, but equally it can protect white Afrikaners if they are being attacked on the basis of their race. So it applies to everybody. Thanks, Chair.
No, thank you very much. I think here, I think we have done justice to the debate. I think at the end of the day, what is left is for parties to make their stance or to take their stance, which is part of the process. Once we start coming to finalizing, I think we will give time to generally parties to state their positions. Can we move to the next one?
Thank you, Mr. Chair. Now we are at the point where the committee would possibly like to discuss the grounds. The proposal originally in the first version of the working document was to, sorry, Chair, I see my deputy has got his hand up. I don't know whether it's a legacy hand.
Deputy Minister?
It is, I won't say it's an old hand, I'll say it's a legacy hand, Chair, thanks.
Okay, thank you very much.
Thank you, Mr. Chair. I also agree that we should rather maybe refer to legacy hands or historical hands. Chair, we've got three options for purposes of defining the term grounds. So I will hand it over to you and the committee members maybe to discuss. I don't think the definition that I'm highlighting now is still going to do the trick, if I may put it that way. So it's a question of going down to the options and maybe deciding which one of the three is most acceptable. Thank you, Chair.
Chair, maybe if I can just assist, maybe what Mr. du Preez should do is speak about which factors. Okay, the option 1 has A to J. Option 2 has less. Option 3 has even less. So maybe he should just point out what grounds are not in option 2 and what grounds are not in option 3. That may assist.
Yes, I think so.
Thank you, Chair. So in option 1, we've got albinism, ethnic or social origin, gender, HIV and AIDS status, national migrant or refugee status or asylum seekers, race, religion, then sex, and sexual orientation, gender identity or expression, or sex characteristics, and then or skin color. With regard to option 2, we've got albinism, ethnic origin, gender.
Sorry, Mr. du Preez, why don't you just say on option 2 which ones are not there that were in option 1?
Mr. Chair, I apologize profoundly. When I prepared to present this bill to you, I didn't look at those factors, so I won't be able to give them to you off the top of my head. But let's quickly.
Mr. du Preez, let me help you. In option 2, skin color is not there. There's one other one that is not there. Yeah, but it's definitely skin color is not there.
And social origin, yes.
Social origin, yeah.
Yes.
No, you've got ethnic. You've got ethnic or social origin, but there's something else that's missing. Sex is not there.
Yes, Chair.
I don't know if that was that intended.
Yes, Chair.
Oh, okay.
Yeah,
that's what I meant, because I think it'll be easier for the committee. So option 2 is what's in option 1, except for it's only ethnic origin, not social origin. It is not sex. Sex is not a ground, and skin color is not a ground.
Yes, Chair. And then option 3 is the more limiting or limited option. But in option 3, social origin has been included. I apologize, Chair. I'm not of much.
Chair, maybe just to assist that option 3 is everything that's in option 1 from A to G, and then it does not have sex, sexual orientation, or skin color.
Maybe what we need to do is to say to members, because they know which options did they suggest, do these options capture what was suggested?
Yes, Chair, if I may, sorry, I didn't put up my hand.
Please proceed.
Yes, I do believe the different options do capture what has been suggested. From our side, I think we requested option 3 ultimately, and the argument remains that as we understand the guidance given by our Constitutional Court, criminalization of hate speech should only be considered in circumstances where other measures has failed And it was on that score that we started with a point of departure being the constitutional provisions around unprotected speech, and then to be expanded in a limited way through developments, and I think what was presented before this committee. So to cut a long story short, Chair, I think those are properly captured, and option 3 was the product of, I think, specifically that argument. Thanks.
Thank you very much. So your option is option 3. What are the views of other members with the guidance on which preference would you opt for? Honorable Mr. Kochele.
Thank you, Chairperson. I think yes, the department captured exactly what we wanted to be included. And then, Chair, but on the grounds, I think I'll go with option 1, because even if when we started, the issue of the skin color and all these issues, they are included in the Constitution anyway, Chair, in terms of the rights that we need to be protected. So I think I will go with option 1, Chair. Thank you.
Thank you very much, Honorable Jelle. Honorable Stephen Swart.
Chair, I think I earlier gave an indication when it wasn't the correct time that we would go with option 3. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Nivo.
Thank you, Chair. Thank you very much, Chair. I think Honorable Jelle covered me. I also support option 1. Thanks.
Thank you very much, Honorable Nivo. Honorable Yako, I'm volunteering you. Honorable Yako. Okay, that's fine. So I think we've got 2 options. I think we can move on this one. Let's go to the next item. Oh, sorry, I forgot. Honorable Mulder, can I volunteer you?
Thank you, Honorable Chair. I also support option 3 then.
Option 3. Thank you very much. My apologies for not volunteering you earlier. It's not a discrimination. Thank you very much, Honorable Mulder. Option 3.
Chair, can I just get clarity if I'd understood it correctly? Is the DA not supporting the inclusion of sexual orientation as a ground, given that in Kwelane, even though that was civil, that was allowed, but I just think your gay or lesbian members should know that you are not supporting sexual orientation as being a ground for hate speech.
Yeah. No, thank you very much, Deputy Minister. Let's proceed.
Thank you, Mr. Chair. Clause 2, nothing to discuss there, obviously. Clause 3, the proposal, and it comes to the whole issue of excluding the common law offense of criminal injuria and then the offenses of hate speech. That's actually the major inclusions in the proposal, which is primarily then merely a redraft of the subclause 1 as introduced. Don't know whether you want me to pause here for a while, Chair.
Yes, are there any takers? on the proposal? Let me check my, no, none.
Chair, we're basically, we were proposing the proposal. That's why it's not an option, as a better formulation of what was originally submitted. So that proposal, both proposals are actually coming from the department.
Yes. No,
As
I was,
better formulations. Sorry, I don't know if I've misunderstood.
yes, no, I was inviting comments on the proposals that we have made. So I take that. Honorable
Chair,
Jelle? Honorable Jelle?
I think because even myself, Chair, since I don't have a comment on this, but because it is the work of the department, and I think both the proposals, they can advise us and take the best, because from my side, Chair, I don't have a comment.
Okay. No, we take it that members up to now, they're still fine with the proposals. Let's proceed.
Yeah, just maybe to point out that they're not alternative proposals. The one is a redraft of 3.1, the other is a redraft of 3.2.
Yes.
And Chair, maybe while I'm on the floor, just with 3.3, that you know, prosecutions in terms for hate crimes have to be authorized by the DPP. Well, hate speech as well. So it's or a person delegated by them. So the decision to prosecute is again also taken at a senior level of the NPA. Thanks, Chair.
No, thank you very much. Let's proceed. Offense of hate speech.
Thank you, Mr. Chair. Before we get that, and please indulge me, should we submit the document as is now, tomorrow again to the committee, or are we going to proceed with the document? Should I prepare another version of the working document, or will we be able, the committee be able to work on the current working document? Just your guidance, please, Chair.
I think there are changes that were made, especially at the beginning. I think it would be important that because we've got option 1 and option 4 and 2 that were combined, so that members are not confused, that we can have a much cleaner document. I think there's not too much of work to be done, but I think it would be helpful to just have a distinction between these documents that we would have worked on today and a document that would indicate progress that we have, that would have already made by tomorrow.
Thank you, Mr. Chair. So in this regard, I will most probably then also delete this portion from the document for you and proceed with the proposal then tomorrow.
Okay.
And then with regard to the proposal in sub 2,
maybe Honorable Mr. Dupree, let's have a proviso that says if we do not finish the document today, then we would still use the same documents, because we would have been working, in fact, we should be working on the same document. But if we finish the document by 1:30, then you can work on the new cleaner document. But if we are not done, then there will be no need to bring a new document, because we will still be working on the same document. So I think that is what we would have to make a decision on by 1:30. So if we are done, it's fine. Then you can make in fact the necessary amendments and clean the documents, so that we are working on a cleaner document. But if we are not done, there will be no reason to work on a cleaner document when we have not finished even the same document.
Thank you, Mr. Chair. So I'm taking the cue from you, so I'm going to start talking a bit slower now. And taking you through the bill at a much lower pace.
Avoiding something.
Chair, with regard to sub 2, the provision as introduced indicated to us, and I would just like to highlight it to the committee members, any person who commits a hate crime is guilty of an offence and liable on conviction then to a sentence as contemplated in section 6 of the bill. However, we have explained on 2 previous occasions to the committee why it might be more appropriate to say that or determine that a person who has been found guilty of an underlying offence must be found guilty of a hate crime, just to ensure that the criminal record of the person reflects the fact that he or she has committed a hate crime, just to avoid the situation where you find that the person has been convicted of a hate crime, but the one gets a fine and the other one gets a imprisonment sentence. Then sub 3, once again, nothing to mention there. When we get to the offence of hate speech, the option 2 we have discussed this morning, or the committee has discussed it earlier. It's maybe just a question of pausing here to get an indication whether the whole issue of the word cause is still a problem, and whether we should maybe rather delete that word in option 2. So I'm in your hands, Chair.
Thank you very much. Any takers on this one?
Chair. Swart.
Sorry.
I have Honorable Swart, Honorable Jele, Honorable.
No, Chair. I think, again, this is at the heart of the hate speech, and one wants to bring it as close as possible to section 16.2. So I would, and I fully appreciate what Mr. Dupree said. The insertion of the word cause might have been said at a previous meeting, but my intention, or as I understand it subsequently, would be to delete the words cause of. So you would only have to demonstrate a clear intention to incite harm, and that would be in line with section 16.2 of the Constitution. So that would be my formulation. So I would suggest to reflect that would be to delete the part in yellow, those words. Thank you, Chair. To correctly reflect that. Thank you, Chair.
Thank you. So you support option 2?
Yes, thank you. With the deletion of the word cause. Thank you.
Thank you very much. Honorable New Vote, Rohan.
Thank you, Chair. I just want to be clear. I wanted to ask Mr. Dupree, there needs to be a comma after advocate, because when you read it, it doesn't look correct. Advocate, comma, makes able, or. So like, because the sentence is not reading properly. Propagates, comma, advocates, or makes, comma, makes available, or that, I'm not sure. It doesn't read. Yeah, that looks better.
So, okay, with the 2 options, which one do you prefer?
Oh, sorry, Chair, let me just read it again.
maybe as you are reading it, let's go to Honorable Jelle.
Thank you very much, Chair. I think I'll stick to one, Chair. The reason being, Chair, the issue of harmful, in the definition, we talk about the harm, and that thing must be harmful, Chair. It must have the intention to harm, harmful or to incite harm, and promote or propagate hatred. I think I'll go with option one, Chair.
Honorable Jelle, there is a sound here that is disturbing us.
Yes, Chair. Where I am, Chair, I'm not far from the noise. There's a funeral here and it's my relative. I'm not far, Chair. So I wanted to be in the meeting.
Oh, okay, no, our condolences.
Thank you, Chair.
Thank you very much. Honorable Swartz, followed by Honorable Deputy Minister.
No, thank you, Chair. I just wanted to again, I think I and the DM have had this discussion before, but clearly understanding if you insert the words be harmful, that would be an extension of what is excluded under section 16.2, which is the limitations on freedom of expression. Now, if you stick to the words of section 16.2c, and I think the challenge is because it's almost been switched around, in as much as the Roman 1 actually is the second part of section 16.2c, which states, and that constitutes incitement to cause harm. That's that element. Then under Roman 2, you've got the advocacy of hatred that is based on grounds. Promote or propagate hatred, although those terms aren't defined, one presumes that it is advocate. So I would appreciate, and I think the DM previously conceded that the insertion of the words be harmful does extend or make it broader and impacts on the limitation of freedom of expression in a way that is not set out in 16.2. I'm not saying it's not permissible, but I just want to re-emphasize we are dealing with criminal matters here, and it is important that we also, as I've said before, whilst we have been following Quilani, and it could be that Quilani allows for this formulation, but we are dealing with a criminal sanction that does require a higher threshold when you deal with that. What I would also like to ask, and again, we've correctly reflected the options, but what is, when we deal with the exemptions, we refer specifically, and we use the wording of section 16.2c, when we speak about advocacy of hatred, etc., we go back to that wording. And that is the phrase where Honorable Horn asked for the word physical to be inserted. But here we seem to move away from the words of section 16.2. And it's a belated issue, but maybe the DM, the words are probably the same. But is there, why, and it is late in the day, but why do we use the words promote or propagate hatred as opposed to advocacy of hatred, which is used in the Constitution? So I appreciate the opportunity just to have this input on the particular words of be harmful. And that's why I would suggest option 2, which is incite harm, and promote or propagate hatred, which is in line with section 16.2, would be the opposite way to go, given the higher threshold required for a criminal sanction that we're now dealing with the possibility of imprisonment. Thank you, Chair.
Thank you very much. Honorable DM, can I, just before you come in, allow Honorable Nivot Truchan, Honorable Horn, then you can come in.
That's fine.
Thank you, Chairperson. Option 1, I would say, but after what Honorable Swart has just said now, I'm not sure if the department is going to rephrase it again. especially on the be harmful part, or they're going to leave it there. But I think I would go with option 1, that it reads better. Yeah. Thanks, Chair.
Thank you very much, Honorable Nivot-Struchen. Honorable Horn.
Yes, thank you, Chair. Once again, for the reasons that we are, of course, embarking on a process of criminalizing hate speech, we would support the arguments of the Honorable Swart around why we should phrase option 2 in the manner it's being phrased finds favor with us. We support option 2.
Thank you very much, Honorable Horn. Honorable Deputy Minister.
Chair, thanks. Option 1 is basically the wording of Papuda with one change, and that is the or becomes an and. It's what the court found with the reading in Papuda to be constitutional as offensive speech. Let's just remember that 16.2 is not a limitation of freedom of expression. It is specifically what is not free expression, what is not allowed under free expression. Under the limitations clause, you then can bring in other issues, and that is what Papuda did. So whether it's criminal or civil, it's allowed. And that's why we wanted the wording under option 1, which follows what the court has accepted as constitutional. And that is, yes, that is a different wording to 16.2, but 16.2 is what is not hate speech. Sorry, what is not free speech, rather than a limitation of free speech. This stuff under 16.2 A to C is not included under freedom of expression. So that's sort of basically it. And then just for Mr. Swart with the exemption, obviously 16.2 is a lower bar, or no, a higher bar rather, to hate speech, and that we felt should apply to those 4 exemptions, therefore giving them a partial exemption, with the people in those 4 categories, or the groups in those 4 categories, should not say things that constitute incitement to cause harm. So it's not promoting or propagating hatred. It's simply advocacy of hatred that constitutes incitement to cause harm. So I don't know if that helps it, Chair, but that's what we've taken that because that's what the court accepted in its reading in as far as Papuda. Thanks, Chair.
Thank you very much.
Yeah, sorry, maybe the officials can, if I haven't explained too well, maybe they can add.
Ms. Botha, Mr. Dupree.
Thank you, Mr. Chair. I hope I'm not stirring the hornet's nest now, but you get this constant reference in the committee to Kwalani is civil and we're working with criminal here. That is correct. However, what I would like to point out to you is that this bill does not propose to amend the law of evidence. So in a criminal matter, you still have to prove culpable homicide beyond reasonable doubt. In a civil matter, if you claim for loss of income, the burden of evidence is lower. So I just wanted to mention that to you. I personally don't think the whole distinction between this bill is criminal and Kwalani is civil is a very strong argument because we are not changing the law of evidence. Thank you, Chair.
Thank you very much. I think parties already they've made their preliminary choices. Others are for option 1, and then others are for option 2. Can we proceed to the next one?
Thank you, Chair. Mr. Chair, that is then the partial exemptions with regard to freedom of expression. And the proposal is there, and with regard to paragraph T, there are two options available, including the proposal that with specific reference to, if I'm correct, I just need to check my records for the meeting of today, the word physical will relate to option 2 only.
Are you done?
Thank you, Chair.
Thank you. Are there any takers?
Chair, Swart.
Honorable Swart.
Okay, as you might recall, we did suggest option 2. The DM did point out there could be a challenge with the issue of religious organization as a person is referred to in the beginning, so I appreciate that. But I think it's very important for us also to just make it clear that the exercise of religious freedom is a very important exercise, and that is the reason why, going back to the department and the DM engaged with the religious communities, and that resulted in this and other exemptions, and we appreciate that. And the question is, of course, why the whether the exemption goes far enough, and there's a view that it doesn't, and that is why we've got the option 2. But I do think it's very important to just again emphasize that we are dealing with hate speech here, which is way beyond merely offensive language. And I think it's, and again, there are a number of judgments in this regard. I think going way back to the S versus Lawrence Solberg judgment, that the right to religious beliefs is not only to experience that and to partake in that, but also to declare those religious beliefs openly and without fear of hindrance or reprisal. And that is why this delicate balancing needs to take place, as pointed out by the Honorable Horn earlier. And I think it's very important to understand that when we are dealing with this deeply held religious convictions, and again, the Constitutional Court has highlighted this in various judgments, including in the Christian education judgment. For example, the court said that the state should, wherever reasonably possible, seek to avoid putting believers to extremely painful and burdensome choices of either being true to their faith or respectful to the law. Now, here we're creating a criminal law with a welcome religious exemption. The question is whether it goes far enough. And the examples that were given are opportune, and one can have a legion of examples. And so I think a lot revolves around to what degree, and the DM did give us some examples of that, but whether this captures the sentiments that a person could express or advocate or lobby under from a religious perspective. And take, for example, a Catholic Church member who expresses strong views against abortion. Now, that could result in a person that has had an abortion feeling emotional or psychological impact of that. Does this sufficiently cover such a person, where at the moment it doesn't cover possibly the private domain? And so this is why we've inserted these additional issues of conviction. Proselytizing might be a very narrow construct. So I think we need to be very careful as we strike the balance between not only what is sought to achieve by the hate speech, the hate speech clauses, but at the same time balancing with freedom of expression and freedom of religion check. So that is why we would urge for option 2, with that insertion of physical, which narrows it down and would make it more, in our view, constitutionally compliant. And I think at the end of the day, given that this is a criminal matter, and just Mr. Dupree, I appreciate what you said. The only reason why we keep referring to the distinction between civil and criminal is that the rebut principles of international treaties all say the criminalization of hate speech must be a last resort. So I really appreciate the comment about evidence that is applicable, but I think that needs to be in mind. So that, with that short input from my side, Chair, I would just motivate for option 2. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Niveau Truchen.
I didn't have my hand up. Oh, sorry, Chair. It is a legacy hand. My apologies. I wasn't aware of that.
Thank you very much, Honorable Jelle.
Thank you very much, Chair. I think this matter, we spoke about it early when we were discussing Honorable Horn raising his own views on this matter. I think I still stick with option 1, Chair. The reason being, these matters, there's a thin line, Chair, when it comes to the hate crime and the hate speech, when it comes to the religion, Chair, and as we discussed earlier. I think, Chair, I still maintain that
Honorable Jelle. Honorable Jelle.
this.
Honorable Jelle, you are muted.
Unless maybe I'm convinced. You don't hear me, Chair?
Yes.
Can you hear me, Chair? Option 1, Chair.
Option 1.
Thank you. Yes.
Thank you very much, Honorable Yako.
Thank you, Chair. I think I'm just going to be Switzerland on this one. And maybe when we have an opportunity to come back to it. I'm still not quite understanding between the two, which one to go for at the moment.
Thank you very much, Honorable Mulder.
Thank you, Honourable Chair. I'll be short. I support the arguments and views of Honourable Swart, so definitely option 2. Thank you.
Thank you very much, Honorable Deputy Minister.
Thanks, Chair. I'm now in the car, so can you hear me?
Yes, we can hear you.
Okay. Just to say, let's start with physical harm. 16.2, which sets out what is not free, which is not free speech, just talks about harm. It doesn't qualify it as physical harm. So I don't know why. So for example, it is propaganda for war, incitement of imminent violence, advocacy of hatred. I don't know why that is based on different factors and constitutes incitement to cause harm. So I don't know why some members want to qualify harm with physical harm. The Constitution doesn't do that. Then, as far as the two options, sorry, you went back. No, you've gone too far now. Okay, here we are. That's what Mr. Swart has added is conviction, and I think he needs to say where is conviction not covered by tenet, belief, teaching, doctrine, or right. Underlined in option 2, but it shouldn't be as conviction, a religious conviction. And my question is, okay, Mr. Swart, what are you trying to cover that's not already covered by tenant belief, teaching, doctrine, or writings? Then his other addition is having it by a religious organization in public or private. The individual I'd see as being necessary if you have an organization to add to it, but actually it applies to individuals. So if you don't put in religious organization, the difficulty is going to be, what is a religious organization? We had that case of that guy running a guest house at Sodwana Bay who had very racist attitudes, which he claimed were based on his interpretation of the Bible. If he were to form a organization, and I mean, remember, apartheid was justified. I mean, people like denying it now, but apartheid was justified on the basis of the Bible by the people in power at that stage and their denomination of their particular type of Calvinism. So it's possible for Christianity, for any religion to be very narrow and bigoted. And we don't want an issue where just because an organization claims then to be a religious organization, that it gets protection under here. So, Chair, that's my concern about the intention of this partial exemption was to allow freedom of religion. But I think what Mr. Swart must explain about conviction, the issue of religious organization, I just find will be unenforceable because what is an organization? It's the individual who's got these views, which is based on their religious belief. And the public or private, look, we've already seen that people say things in private. Maybe in private would be on a WhatsApp group. They say horrible things that are extremely harmful for people, and there's huge outcries. So the issue of what you say in private should not be protected. It's a question of are you interpreting or proselytizing or espousing any religious tenet, belief, teaching, doctrine, or writing in terms of what you say. I hope that explains. Again, maybe you'd want to give the officials the chance to add.
Mr. Chair, I would appreciate if I could immediately respond to that, and I agree fully with the deputy. When we look at option 2, and once again, my responsibility is to advise the committee on technical drafting issues. What I say in private, or what I smoke in private, is my concern. It doesn't concern anyone out there. The example of WhatsApp or whatever, that's not private. But at least with reference to option 2, the reference to private is honestly unnecessary. I don't agree with that. I oppose it strongly. If I and my best friend meet and have a conversation in the privacy of my house, I can say or smoke or whatever I want to do in the privacy of my house. So I don't know why this, and I can't understand why there should be reference to the words "or private." I honestly don't like, as a drafter, confirming the existing law in another piece of legislation. Thank you, Chair.
Thank you very much. I think we have exhausted everything for today, as we agreed that we will be done by 1:30. It's now 2:50. Can I suggest the following? One, that tomorrow we will proceed to finish the document. That is the first thing. Secondly, the department would, on that issue of social, they will, I think they would have developed other arguments, and they will also take us through that. And then we will conclude I think we will conclude our work tomorrow, which we will give time to parties to finally concretize their positions. But we do have an indication now. We might, committee secretary, what is happening on Friday? Because I see there's nothing on the committee program.
Chairperson, there's nothing scheduled for Friday.
Chair, if I can ask, I'm not available on Friday because the cabinet Lokutla has been moved. So if it's possible, I wouldn't be able to be there on Friday. Maybe some members don't want that, would like that, but I would request that it be at a time when I'm available.
No, maybe what we can do is that let's conclude the bill tomorrow. In fact, what we are doing now. And then thereafter, what we will do, we will deal with the legislative program tomorrow. And then we will follow the program as to the next date available, which is reflected on the program, where I think we will be finalizing the bill. I think we are moving quite nicely. We should be finalizing the bill soon. So after tomorrow, we will be much more clearer as to that after tomorrow, the next date we will be having, it will be to finalize the bill. But Deputy Minister will request that tomorrow be available to brief us also on the legislative program, so that we don't meet next week, I think Tuesday. Members, you know that there is a joint sitting next week, and then there is that meeting with the heads of institutions. But when I spoke to the chair of the Human Rights Commission Committee Secretariat, they had not yet received an invitation to be with us on the 8th, and that's concerning. So if you can attend to that. And then I think what we also need is for the logistical arrangements, if you can be briefed about the logistical arrangements of the 24th of February by the committee secretariat. We do agree that we will use our entitlements to fly to Johannesburg, but there was also a view that we might need to meet with the Legal Aid Board. My concern is that even if we were to invite the chairperson of the Legal Aid Board on Tuesday, because they've not, seemingly the secretariat has not invited them, it is a little bit too late. So maybe we must use the date of the 24th to meet with them in Johannesburg, the Legal Aid Board, and maybe we can do also some visits to some offices of the Legal Aid Board. Members, if that is in order, can we close the meeting for today until we meet tomorrow at 9:30?
Okay, Swart, yeah. And I see the DM's hand is also, I really appreciate the fact that we aren't meeting on Friday. That is my Lydia Meshra's memorial services on Friday as well. And I was going to suggest, is this an appropriate time so that I can respond to the DM's time, but we can, if you allow me, when we come back tomorrow, just a brief response to what was raised, not to belabor the points today. So I'm in agreement, we should adjourn now. Thank you, Chair.
Yes, no, we will meet tomorrow and not on Friday. Honorable DM, is it a legacy hand or an...
Chair, it was a legacy hand, which should be down now on everybody else's side. But thanks very much, Chair.
Thank you very much. The meeting is adjourned.